Yes, please.
May it please your lordship. I am praying for listing of a bail application, my lord, regular bail application tomorrow, my lord. Yes. To mention item 45 of daily list, my lord. Can it be upgraded, my lord, taken before 3? I have a professional engagement, my lord. Before 3, my lord, anytime before 3.
Yeah, no problem. We'll accommodate you.
45, my lord. Grateful, my lord.
Lordship, I beg to mention item 37. In the instant mail application, charge sheet has already been submitted.
Okay. So you can take it up if you want. You want it to be adjourned?
Withdraw, Lordship.
Withdraw.
Yes, Lordship.
To prefer that there. Ms. Bora, right?
Yes, sir.
Land Counsel, P. Bora, Land Counsel for the petitioner submits that in the context of submission of charge sheet, he has instructions to withdraw this matter, as the petitioner might prefer to seek a regular bail before the learned trial court. The prayer is allowed. The bail petition is disposed of upon withdrawal.
Deeply obliged, Lordship.
Maybe Lordship. Lordship, I'm praying for listing a criminal petition for tomorrow.
Criminal petition.
Criminal petition, my lord.
Criminal petition. Bail, it's okay, but is there some urgency? It can be
Yes,
after
my-
vacation. After
I'll
vacation.
change there, my lord.
What do you say?
And-
Because today we are hard pressed actually for time. Lots of cases. Okay, list, but please list only the urgent matters, and of course bail you can. Okay, I allow. I left. I don't know whether.
May I
Yeah,
please your
yeah.
lordship? I beg to mention for listing one regular bail application
Yes.
for tomorrow, lordship.
No problem. Bail, no problem. You can give.
Deeply obliged.
Others also you can give bail.
Similar prayer.
No problem.
Similar, I have also similar plan, my lord.
Bail listing allowed, all.
May I please, your lordship? With the consent of the other side,
Yes.
may I please, with the consent of the other side, I beg to mention item number 38 for adjournment due to medical emergency of my senior.
Scan case here. Okay. When? After vacation?
Yes,
After
after vacation, any day.
Learned counsel submits that due to some medical issue of the leading counsel, the matter may be adjourned today,
Lordship, interim is there. That means
listed after the vacation. Scan TCR is available. The interim bill fight so and so stands extended till the next date of listing. Let us list it immediately on reopening, since interim is there. 13. 30. Kindly inform the amicus.
May I please your lordship. With the consent of the other side, lordship, I beg to mention item number 48.
Okay.
Lordship, we have filed our rejoinder to the interlocutory application yesterday, so it is not on the record, lordship.
It has to be brought on record.
Yes.
That's all.
So it may be like listed after the case.
What is?
Interim may continue, lordship.
You are for the opposite side.
Yes,
I'm
lordship,
for
in
the
the I am
applicant
for the opposition.
respondent.
Applicant respond. You for the petitioner.
Yes, lordship.
And counsel of the petitioner submits that in the IA, in the interlocutory application, they filed a rejoinder. The same may be brought into the record, the matter posted after the break. The learned counsel for the other side, Ms. P. Hazarika, submits, has no objection. List the matter after, when, any specific date or
Any day after vacation, your
Lordship,
lordship.
interim is still.
interim model by so and so stands extended to the next date of list. List on map 24/7. 24/7.
May I please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 18, your lordship.
18.
1 your lordship. Every weeks after 3 weeks, your lordship. I'm appearing for the response number 2 here.
Your lordship, I am appearing for the petitioner. Your lordship, let the interim alteration continue.
Yeah, that's okay.
1-8.
Third one, so and so. Not counsel for your good name, please.
M. Chandalia.
And
And our Sharma, lordship.
Anna, not counsel for respond number 2. Displayed that the matter may be, you filed some counter.
No, lordship.
The matter may be adjourned for the day and posted after the break. Prayer is allowed. The interim order so and so stands extended till the next date of listing. List on 27. Or we can leave it to registry also. List after 4 weeks on a date to be fixed by registry.
Lordship, another prayer, lordship. In item number 39, your lordship. The PPS told me that the CD is not received. Item number 39.
CD is not received.
I'm on interim, lordship.
Case diary not received. Issue reminder. Interim invite so extended till the next date of listing. List on 28. Yes.
May I place your lordship? I beg to mention for item number 47 for adjournment, my lordship.
47
Yes, sir.
orders. Not today. Order, I don't know what is the matter. Order matter, but learned counsel, Miss. Your good-
Fifth date after vacation, my lordship.
Your good name, please, man.
T. Amit.
Yeah, Amit, learned counsel for the petition. 6, an adjournment. Please for listing it after the break. Any interim order? No. The prayer is allowed. List. Any date or after the vacation?
Sir, between 15 or 20.
List on 17/7.
Lordship, may I please, your Lordship, in item number 54, Lordship, we have filed our objection. Our objection may be called for.
Acha, yesterday's matter, right?
Yes, sir.
Fine. Okay,
Highly object.
objection is maybe brought on. Yes, Mr. Mukul.
May I please, your lordship, I beg to mention for listing a revision petition, lordship. Urgency is that the next, that is fixed on 1st of July, lordship, in a trial court, lordship.
He's
I
not
am
on
previous-
bail. He's not on bail.
Lordship, I am on previous bail, lordship.
And then, no problem.
I have filed in one IA for suspension of sentence, lordship. 3 years imprisonment, lordship.
Okay.
Oblige, your lordship.
May I please, your lordship? I beg to mention item 2, lordship. I may be allowed to draw the petition with liberty.
Learned counsel for the, you're Mr.
S.H. Raman.
S.H. Rahman, learned counsel for the petition. Submits that he has instructions to seek withdrawal of the bail petition. Prayer is allowed. The bail petition is disposed of upon withdrawal.
With liberty,
With liberty to file a fresh one.
lordship.
However, he also seeks a liberty to file a fresh bail petition. The prayers are allowed, disposed upon withdrawal with the aforesaid liberty.
Obliged, lordship.
Wait, please, Lordship.
Yes.
Lordship,
Sure.
NDPS commercial matter. May I kindly call for TCR, Lordship?
All for the scanned TCR of NDPS case number 39 of 2026 from the Court of the Learned Special Judge in RB Anglo. Reference case Khatkati PS 41 of 26. Petitioner was arrested on 26/3/2026. List on
14 May kindly. 14.
29/7.
It's too long, Lordship. This is-
Use
14 or 15, Lordship, preferred May.
fixed many matters actually on this.
Huge quantity of opium, 22.28.
So that's why it will not take time more.
24.
Lordship, may kindly be given the first week of, just after the
I
vacation.
think already many other cases.
Resuming the court, Lordship.
Fixed many
On 24/6.
14, 15 or 16, Lordship. May kindly be given.
17.
Lordship. Obliged.
That's a regular bail application. Petitioner has been custody almost 30 days, now 30 days.
Okay.
FIR will find lordship bail at page 28. So the petitioner has retired as an executive engineer in January 2026
Mhm.
from Assam Fishery Development Corporation. This FIR has been filed in 2022. Lordship will find it date 21/9/2022, stating that lordship serial number 1, 20 lakhs, 27 lakhs and odd were fraudulently siphoned of the name of the preparing detailed project report for submitting to the National Fishery Development Board without any instruction from their end.
Mhm.
Name of the official involved.
Right.
Now, Naren Chandra Bosumatari, lordship will find
Yes.
ACS ex-managing director, Padmakanto Hazarika OSD, and Jyotish Shoikia. Lordship got it. Second is lordship loss of Iman, where my name is not involved. My name is not here. Third is lordship will find transport would be 11 crores. Here my name is mentioned as Jyotish Shoikia. Lordship got it.
Hmm.
And already there is a case in Borbila PS case, lordship will find Belchor PS case number 160 of 2022 has been registered. In the same affair, lordship, the already case has been registered and search sheet has been filed in Belchor PS. And I am not the accused in the search sheet.
Acha.
Only case is regarding lordship the serial number 1, that is Jyotish Shoikia for siphoning money of rupees 27 lakhs.
Hmm.
And this is also period of 2019-21. Petitioner has been joined as an executive engineer in 2022. Lordship will find at page 27. Page 27.
Hmm.
Lordship got it.
Yes, yes.
Petitioner joined as an executive engineer by order dated 17/8/2022, officiate as an executive engineer. Lordship got it. And this is earlier to the petitioner. And this FIR has been filed when petitioner went service in 2022. Now, Lordship, I'll take your Lordship to the page 29.
Uh,
Case has been registered in 23.
Mhm.
Lordship got it.
Page,
29.
yes.
FIR has been
3.
filed in 2022. Case has been registered in 23.
Mhm.
Now, Lordship, petitioner has been arrested on 26/5/2026.
6/5/2026.
26.
Nice.
That is also after 3 years from the date of registration of the affair. Before that, Lordship, the so-called notice is issued to the petitioner. Petitioner has informed to the authority that petitioner was not involved in the case and petitioner has joined subsequently. Lordship will find the so-called reply of the petitioner
At
Lordship will find it so-called reply. Location. Now, Lordship, my submission will be, Lordship, in this particular case, petitioner arrested on 26/5/2026
Right.
and already 30 days in custody. And secondly, Lordship will find that the another case has been registered after Lordship the present arrest has been made. Lordship will find at page 54,
another case.
another case by the same official, same IO, that is page 54. And already Lordship the
Showing
case
arrest.
where the bail has been granted by the learned special judge, special magistrate, Lordship will find the final order at page Lordship will find at page 77. Page 77. Lordship got it.
Yes.
Accordingly, bail application 1 to 6 stand allowed. Accused person, namely Padmakant Hazarika and Jyotish Shakya, shall be released on bail in connection with the PS case number 190 of 2022.
Mhm.
That is also earlier case when I am not there. Petitioner has been already granted bail in the another case which has been shown to be arrested.
The FIR in question is the one which we saw at the beginning, right?
Not it.
The
Present affair is
ACB case, this one.
ACB
of
PS
22.
page 28.
22.
28. Page
so,
28.
Yeah, page 28.
Page 28.
It was dated September 2028.
September 2022 and registered on 2023. Now arrested after retirement from service on 26/5/2022. A petitioner has already retired from service and there is no question of any keeping on custody of the documents or anything. Everything has been seized by the police official. So there is no question of custodial interrogation now and no keeping of petitioner in jail. And already Lordship will find another accused who was the main accused in according to me, Lordship, he has been granted interim bail. Page 94. In the same case. Page 95 is the interim bail has been granted also. He also retired from service. He was an extension. I have retired from service in January 2026. So I pray, Lordship, I am also suffering from various ailments. I have employed the documents regarding my ailments. So considering this, Lordship, I may be given at least interim bail till CD is called. Lordship.
Yes, my lord, first of all, my lord, serious allegation under PC Act, my lord. And regarding the my lord, accused number 1 who was granted bail, your lordship may kindly come to the bail order, my lord.
I've seen.
That accused person suffers from bone marrow cancer, my lord. Regarding that, some documents also only on that ground interim protection was granted, my lord, on that day. And regarding the present petitioner, my lord, also he is accused number 3, my lord. There are lots of allegations at this stage. My prayer before your lordship without my lord,
Lordship will find
pleading, my
another
lord,
thing I like to
not
mention,
grant
Lordship, page
interim
85.
protection, my lord.
Rejection order by special judge.
No.
Page 85.
85. Can get the case
How-
immediately after reopening.
Lordship, can you
Yes.
see one thing, Lordship? I like to place because Honorable Special Judge has rejected the bail application after considering the materials on record after page with the CD. What is the finding, Lordship? You will find
Page 85.
page 85, para 13. In relation to the pending bail petition, I have scrutinized the case diary. Lordship, got it? Which includes report forwarded by Director of Finance Inspection, Government of Assam, statement of various witnesses, various seized documents, contain a letter dated 15/5/2006 issued by the Managing Director LBC, connection with the annexer and letter, page 78. illegal fund transfer of AFDC was there in the individual personal saving account of accused Birinsi Odhikari and Jyotish Prasad Saikia. Jyoti Prasad Saikia. I am not Jyoti Prasad Saikia, Lordship. Lordship would find again, I will take your Lordship to the affair. Page 28. Page 28. Page 28 again, Lordship. Wrongly here, my bail application has been rejected. Lordship will find page 28.
Jyotish Sakya.
I am Jyoti Soikia and Jyoti Prasad Soikia is serial number 5. Serial number 5.
Jyoti Prakash Sakya. They are two different persons.
Two different persons. But I have been considered that money has been transferred to my account.
This we have to see it and anyway.
Lordship, I have also the medical documents. I am suffering for various ailments. That is why, Lordship, I want only interim bail till Lordship this CD has been called. And Lordship, there is no question of anything be concealed by me at this stage.
Anyway, so
And police has not asked for any custodial interrogation now.
just a minute.
My prayer before Lordship at this stage, my lord, only because principal accused person was, accused number 1 was granted, my lord, that is order is there, my lord, only on the ground of, my lord, as because he is a cancer patient, my lord, and only on that ground interim protection was granted. And
Page
regarding the-
93 is my medical document. I am
And-
suffering from Lordship various ailments.
Full stop.
At least still Lordship CD is called Lordship.
For those ailments, my lord, jail.
Because this is not an order of conviction Lordship. Only during the investigation period,
Anyway, let's take some plan and he bought up.
My prayer before Lordship at this stage, only CD may be without granting any interim protection.
Invoking 483 BNSS, the petitioner Jyotish Sakya seeking regular bail in connection with ACB PS case number 30 of 2022 under so and so section. The case arose out of an FIR dated 21/9/2022 lodged by Deputy Superintendent, lodged by Managing Director of AFDC, Assam Fisheries Development Corporation. Several persons are named in the FIR, including the present petitioner. The gist of the allegation is about financial irregularities and misappropriation in the AFDC fund from the period 2019 to 2021. The amounts various amounts are mentioned running into several crores. Full stop. The petitioner is stated to have been arrested on 26/5/2025. 26. Mr. Goswami, our counsel submits that the petitioner was working as executive engineer and he has in the meantime already retired from service. Full stop. And since he is not in service, his continued custodial detention will not be necessary. As also the documents, many of the documents have already been seized. Full stop. The learned counsel prays for interim bail in the arrival of the case diary. It is submitted that a co-accused have been granted bail.
Interim bail.
Interim bail. So it is submitted that the petitioner has some ailments as well. So
Petition page 93 is a document Lordship.
the learned additional PP, Mr. Botakur, prays for calling for the case diary while opposing the prayer for interim bail at this stage, further contending that there are a lot of allegations regarding corruption and financial irregularities to the tune of crores of rupees. Full stop. I have given my consideration to the matter. At this stage, the prayer for interim bail is refused. Call for the case diary from the concerned police station. List on, you can give immediately after.
Yes. On
When?
16/7 already CD has been fixed in another.
16th. Should I place it before the same bench?
No, schedule.
16/7.
On 16/7 also. 16. Obliged. And already may I submit one thing Lordship. In Belchor PS already search sheet has been filed and I am not the accused. I have the copy of the Belchor PS also.
It is also submitted by Mr. Goswami, learned counsel. Okay, that is important. That the petitioner was also arraigned as an accused in one Belchor PS case number.
Lordship, Belchor PS case number
This file has been
162 of 2022.
160.
162 of 2022.
62 of 2020. And upon completion of investigation, the case has been charge sheeted, but the present petitioner has not been sent up for trial. We see that.
Obliged.
Item number 4.
Please, your lordship. Lordship, the matter may be passed over for the time being. POSCO is there.
May I please, Lord? 483 application, Lordship. I'm always almost 54 days behind the bar, your Lordship. FI page number 13, your Lordship.
Laluk Pearson.
Page number 13.
1-3.
1-3, your Lordship. Lordship. Section 10 is added, section 10 is there, your Lordship. Kindly, your Lord, arrest, page number 21, I look to type copy, that is arrest, may have a type copy, your Lordship.
Yes, sir.
In this arrest memo, your Lordship, signature of the relative witness of the accused has not been taken, your Lordship. No witnesses, no signature of the relatives has been taken in the arrest memo, your Lordship. One way of violation of the legal rights, your Lordship.
In such a case also.
Lordship.
Anyways,
Notice may be issued.
at this stage, immediately after vacation.
The one more point I will place, the order of the rejection order that is page number 25, your Lord.
Yes.
Is on the middle part, you know, on receiver notice, that is and no objection has been filed here by the informant. On receiver the notice, the Lordship, the informant had appeared before the court and filed petition so and so.
Learn special PP. No.
No objection has been filed through special PP in that court.
How come? Oh, no, I think the informant has.
Informant has
There is no objection.
No objection already, but through special PP that's filed. Considering this aspect, I may be allowed.
See this immediately after. Third.
I'm already.
Hmm.
It may be during, can it be during vacation, your Lordship?
No, so we have notice will
No,
not be.
no,
submitted.
no, no
Notice will not be,
notice.
there may be other matters also, right? 483 bill application. Call for the case diary of Laluk PS 90 of 26. The petitioner was arrested on 1/5/26. Steps of notice may be taken upon the respond number 2 through the office standard, office of the learned public prosecutor, and to be executed through the concerned police station, whereafter the prosecution shall take instructions regarding such service. Okay, standard. Immediately after we can.
Yes.
13, can it be on 13?
Yes, ma'am.
13.
Lordship.
6 NDPS commercial search sheet submitted.
Sir, charge sheeted matter, my lord.
Okay.
And here also, my lord, he is paying of bail on the ground of my lord, violation of section 36, which is page 38, my lord, annex of 5.
Page,
Page 38.
section 47.
Yeah, not, my lord, it's based on section 36, my lord.
At this stage, scan PCR.
In fact, the column was not also available, my lord, where the signatures of the relative or the witness of from the local, my lord, local person has to be.
Police have to be told about these things.
Yes,
Yeah,
ma'am.
no.
There are some instruction,
Taking it too
needed.
casually.
Otherwise, everywhere, wherever quantity is, used, everywhere, this type of, say, continuously, in recent time also, it is a matter of concern,
A matter of concern. Anyway, let us call for the case then immediately after, after vacation, right? Counsel. Whoever on merits, people should get bail, that's different, but legal grounds. So call for the scan TCR of special NDPS case number 21 of 2026. From the court of special judge Sri Bhumi.
Shivu.
PS case to Nilim Bazar 132 of 24. Petitioner is in custody since 24/9/25. Long time he's been in
Yes.
custody. The learned counsel submits that there is a infirmity in the arrest memo under section 36 of BNSS. Has no signatures of the relatives
Yes.
or other friends or friend or other person has been taken on the same question. We'll see. When do you propose?
16/7.
Okay.
61. Deep level.
Then also my POSCO is there.
May I please, your lordship, 482 bail application, petitioner is behind the bar for the last 153 days, lordship.
6 months.
At this stage, lordship, notice may go and TCR may be called for, lordship.
Call for the heard Mr. Borderland. Special POXO case 15 of 26. Out of PS case, Lalu PS 16 of 26. The petitioner was arrested on 24/1/26. Also take steps upon respond number 2 and again. Okay, date to you take the date.
15, lordship.
Let's see.
15, Dada.
He has a calendar.
15/7.
Can we, okay.
15/7, lordship. Oblige, your lordship.
NDPS commercial search sheet submitted.
Yes, Malad, they are in custody since 28/2025, Malad. And there are also Malad, similar violations these petitioners have raised, Malad. By Annexure 5, page 37 and 38. There also we do not find money any column, Malad, where that requirements has to be complied with.
Anyway, so
Yes, Malad.
same like
Yes,
before,
Malad.
right? You want the same date? You want the same
That
date?
is the-
It will be
Yes,
spaced.
yes, Malad.
Takes time. It's way to recall. Special NDPS 10 of 2026. Karimganj PSS 386 or 25. Yeah, because the petitioners are in custody since
28/2020.
208/2025. Submission non-compliance 36. So list on
On 17/7.
17.
7. Oblige.
May it please your lordship. Lordship, regular bail application. The accused petitioner happens to be a public servant, my lord, and the allegation is of trap, my lord, under 7A of the Prevention of Corruption Act. Lordship, the amount is question is 45,000. So possibly lordship would be keen to call for the case diary in instant matter.
On the state vigilance,
State, my lord, state. My only prayer is that, my lord, as on today, it is 35 days. So immediately on reopening, probably it will be 50 days. So may I pray for the diary on 14th, my lord?
that we
14th, my
subject
lord.
to some adjustment here and there.
Only that accommodation I'm seeking.
14th or 15, my lord.
We get 14, seeking for
14th, my lord, obligement.
Mr. Boyd, Learned Counsel. Call for the ACB PS case number 19 of 2026.
My lord.
That's fine. So he was arrested on 21/5/2026. Full stop. Right. List on 14.
14th.
14.
Deeply obliged.
Lordship, this is second time bail application, lordship. Earlier bail application has been rejected. City may be called for.
CD. Updated CD.
Yes, sir.
It was rejected by
Yes, sir.
heard Mr. in the Learned Counsel for the petition. Clearly submits that earlier bail petition was rejected by this court on 11/2/2026 in AB 3050 of 25. In crime branch PS case number 12 of 2025. Call for the updated case there from the concerned police station. When?
17/7.
7th
Obliged.
AB.
May I proceed?
Yes.
The petitioner, he is a journalist by profession, my lord. And prior to this FIR, my lord, at page 21, and another FIR was lodged, my lord, regarding some extortion by some alpha terrorists, my lord. In that case, my lord, investigation continued, my lord, and some people were arrested. And the arrested persons, my lord, they took his
His
name.
name.
Page 22, my lord, fourth paragraph may kindly be seen.
Page 22.
22. Fourth paragraph. Fourth paragraph starts furthermore.
Yes.
Furthermore, based on the disclosures made during the spot in interrogation of the apprehended accused persons, it came to light that the entire operation was orchestrated by the absconding accused Manas Gogoi, the petitioner before your lordship. Manas Gogoi alias Tom of so-and-so. Acting on this information, a house search was conducted at his residence. Although he could not be apprehended, one factory made 9mm pistol along with one magazine and 4 rounds of live ammunition were recovered from his house concealed beneath his mattress of a bed in a drawing room. Now, my lord, I have also annexed the seizure list, my lord. Page 25, may kindly listen. Page 25, my lord, the seizure list. The seizure list reveals, my lord, the ammunition was seized from one other person, my lord, from other location, Uken Panging. And the location is also different, my lord.
It is stated that it is from his house.
From some
From his-
other person.
No, this
No.
narration says that page 22 narration that from his house
Yes,
under the
yes,
mattress.
yes.
The seizure list indicates from the possession of Uken.
Documents from the possession of
Address is
address is different, my lord. Address is also mentioned here of the petitioner, my lord. Address is mentioned.
Unpura Gohaigaon. Unpura Gohaigaon. This appears to be a different case.
Different.
Purpose of it. What do you say?
Otherwise, if there is any defect in the my lord seizure list, that would be clarified from the city, my lord.
CD.
But regarding other my lord materials, again, your lordship may kindly prove.
As of now, the only material against him is the statement of co-accused.
Statement of co-accused, my lord.
Your lordship may kindly come to page 21, the FIR, my lord.
That has to be seen. He is stated to be the mastermind or something.
Yes, my lord.
No.
With due respect, I have the honor to submit the case pertaining to an extortion demand made to a businessman, namely so-and-so, by suspected members of a band organization, has already been registered at Chipsagar PS so-and-so and under section so-and-so. In continuation of the investigation of the aforesaid case and acting upon reliable source information regarding the proposed collection of extortion money, a well-coordinated operation was launched on so-and-so at about 14 hours. The entire operation was meticulously planned and supervised by the so-and-so.
That is what, my lord,
So they are involved in, my lord, in a group, my lord, they are involved in, my lord, extortion, demand.
That is what, my lord.
Money, my lord, and
In that
thereafter.
other case,
some-
investigation continued, my lord. Some persons were arrested, and the arrested persons, my lord, said that the petitioner before your lordship.
Vehicle was also recovered from him.
Yes.
His vehicle.
So he is
I think
a
it would be
member of
better
the
not
gang.
to give interim, I
involved in
think, but we can fix it in the vacation code if you want, because I think
Because
it may
till
not
now,
be
there
very
is-
prudent, although this aspect is there, some recovery is also there, vehicle is also there. Take it on 2nd or something, 2nd July. Will you be available?
2nd of July.
You may not be available that. If
My-
you are not available, you may not be available.
Available.
What do you say? What happened?
2nd July.
Normal course, that much is okay, that much time is okay. So let us see the learned counsel for the petitioner and additional people stuff. Petitioner is seeking anticipatory bail in connection with. I don't know, I call for the case diary of Nazira PS case number 26 of 2026 under so and so. Full stop. Submission to the court. Drawing attention to relevant paragraph of the FIR dated, what is the date of the FIR?
Dated 25/5,
26/5
26/5.
26/5/2026. Then council submits that the name of the present petitioner has stated to have emerged from the spot interrogation of the alleged persons. Full stop. It is also stated in the FIR about recovery of one pistol from his house, but drawing attention to the seizure list, it is submitted that the same are stated to have been seized, recovered from possession of one
Page 25, my lord.
Uken Panging,
Panging.
and the location of seizure is also different from what is stated in the FIR with regard to the petitioner. This much, no? Call for the, we have already said, list on 2nd July, 27. 27.
MDPS intermediate quantity, Malad.
Lordship, item number 4 also may be taken up with the same Lordship,
Same,
same FIR.
same matter.
Item number 4 also, that has already been pending.
Timing.
This is an allegation is with Lordship, recovery of 50 grams of heroin, 4 soap cases. Here, interesting part in the FIR, Lordship. If you Lordship look at the page
Fire.
13, Lordship. Raid was conducted by Moirabari PS, Lordship.
Mhm.
The jurisdictional area where the search has made is of Lahorighat PS, Lordship. They have mentioned here at page 14, Lordship. Third paragraph, Lordship.
Okay.
The operation of the videographed along with seized items apprehended persons Reki Bhushan and Noor Nehar, both were handed over to OC Moirabari PS. Seized items were kept in the PS Malkhana by demand number through Malkhana in charge. In the last paragraph, Lordship, again, since the place of occurrence of the entire operation are falls under the jurisdiction of Lahorighat PS, so after discussing with OC Moirabari PS, FIR was lodged before the OC Lahorighat PS. Here, Moirabari police went inside the Lahorighat PS area, made a house search in violation of all the laws, and recovered, so-called recovery was made. They came back to Moirabari PS, handed over the articles to Moirabari, but the FIR was lodged at Lahorighat PS. So I am a family member consisting of 4 members, Lordship, the husband, wife, 2 children. The mother and the boy, son was arrested here.
What is the allegation? Some
50 grams, 4 soap cases, heroin.
let me see this.
50 grams, Lordship, almost. 50.73 grams.
Soap cases.
So 4 soap cases, Lordship.
12 cases.
More or less 10 grams or
Yeah.
11 grams each, Lordship.
5
12
grams, 5 grams. That will be intermediate quantity.
50 grams is intermediate quantity.
50. 50 grams will be intermediate quantity. Let's call for the case diary.
I have attached some medical documents of my 7-year-old daughter, Lord, because mother and son is inside the jail, Lordship. Now my daughter is with some of my relatives, Lordship. She need urgent medical attention, Lordship. So till city interim bail may be granted to the Mafidul Islam, Lordship. I am not present at that time, Lordship. I was for work near Arunachal border, Bandardewa, Lordship.
Yes, cases. Anyway.
Otherwise, NDPS commercial quantity,
No, it's not commercial, not intermediate.
Intermediate quantity,
Heroin.
intermediate quantity, regarding AB, that is, I have objection in granting any interim protection regarding those medical conditions that will be looked after by the, in case of, by the jail authority, At this stage, my prayer before Lordship, and regarding jurisdictional dispute, that will be looked after later on. And regarding the admitted fact is that case was registered before Lahorighat police station, and those contrabands were recovered from the residence of the present petitioner, And
They are all family members, right?
All family members,
family
Lordship. In 4, Lordship, mother, I have prayed for the mother and the son, Lordship. We are behind the bar for 30 days, Lordship. Today is the 30th day.
Noor Nehar is a minor son.
No, 7-year-old daughter, Lordship. So I am requesting for a bail, maybe mother to interim bail, Lordship, till CD, to look after my child, Lordship, only.
Heard Mr. SK Porta, learned counsel for the petition. Call for the case diary of Lahorighat PS case number 60 of 2026 under Swens. The gist of the allegations in the FIR dated 25/5/2026 is a search of the house of the petitioners upon some information. And upon such search, soap cases, 4 soap cases containing suspected heroin was found, and the weight of the same was found to be 50 grams. Full stop. Call for the list on second to the petitioner number 1 is stated to be there. He's son of Rakib Hussain is son of
Mafidul Islam and Noor Nehar.
Also the petitioner number 1 is stated to be the son of the petitioner number 2, full stop. It is also stated, submitted that the petitioner number 2 has a minor daughter ages 7 years, and as her parents and brother are apprehending arrest. Oh, they are in custody, right? This is there in custody. This is a AB.
One is AB, one is
Okay,
BL.
sorry. So it's BA.
I'm behind the bar for 30 days, Lordship. Maximum period is 60 days, Lordship.
No, Nehar is,
Anyway, so it is submitted that the petitioner number 2, Noor Nihal, is in custody for 30 days and there is none to look after her minor daughter aged 7 years. Who has
Rakib
been
Hussain is also his son, 22 years.
accommodated in some house of relatives. The learned counsel submits that perhaps interim bail may be considered for petitioner number 2 in the said situation. Call for the case diary, however, only considering the aspect of the minor daughter of the petitioner number 2. It is, and also the fact that she's already in custody for 30 days. Dash. In the interim, it is directed that allowed to go on bail of rupees 50,000 with 1 surety of the like amount to the satisfaction of the concerned learned court, and subject to the conditions that she shall cooperate with the investigation, not hamper or temporary evidence, and shall not indulge in any illegal activities.
The interim to only petitioner number 2.
Only,
Only two.
that's fine.
Obliged, Lordship.
List on, take the date.
Uh,
Again, like a
16/7.
both 16/7, both cases 7.
Can it be made 17, Lordship?
17.
Can be, no problem.
17, Lordship. Obliged, Lordship.
Yes, sir.
Lordship, this is a case under section 21B, Lordship, for PROCEEDINGS, Lordship. Lordship, I would like to draw your honor's, Lordship, kind attention to page number 15, the scissors. Lordship, may I read, Lordship?
Yes.
The page number 15 is the type copy, Lordship. I so and so, this Abrongia PS do hereby see the following items are found from the rooftop of the house of Raju Ali, son of Babul Ali, so and so, which was thrown by Moon Ali, Assam, from the rooftop of his house and fled away from the PO by jumping in connection with the above reference case. Lordship, I am not this Raju Ali, Lordship. I am Moon Ali, and the basic requirements of 21 this offense under section 21B is this has not been fulfilled, Lordship. The petitioner is neither manufacturer nor possessor, seller, purchaser, transporter, importer, exporter, or user of any this drugs, Lordship. And no any articles were found from my possession, Lordship. It is alleged that it was found from the rooftop of the house of my neighbor, this Raju Ali. Then the police has filed, themselves have filed this case. They went to search my house, and by searching my house, they have not found anything. Only my mobile phone was seized from my this wife, Lordship. That is this list is at page number 18, Lordship. The type copy is on 17. This mobile phone is only seized from my house, and no incriminating materials were seized from my possession. Under these circumstances, Lordship, this pending calling for the case diary, I may be protected, Lordship.
Let me have a look at the FIR.
I may be protected, Lordship.
17/6. Anything you can
Your
keep on
Lordship, may kindly
submitting.
come to, which was thrown by Moon Ali. So he is not a transporter. Initially, he was
Thrown by Moon Ali or Raju Ali?
Moon Ali, the present petitioner, my lord. Your Lordship, may kindly come.
I
page-
read it.
Page
differently.
15 Caesar list, my lord.
Thrown by, they had said that
Caesar list has shown by the which was thrown by Moon Ali, the present
That's
petitioner.
right. that was.
So he is not a
Then it
transporter.
will be different. Anyway, let us
Yes,
read the FIR. I'll go through it.
So, my lord,
Page number 13, Lordship.
Yes, sir, 13. Received from Moon Ali, so illegally engaged in purchase and sale of the immediately proceed so and so that. of a neighboring person. Oh, so it's the other way around actually, in a
Yes,
way.
ma'am.
He threw it, according to the FIR, he threw it, upon seeing police, he threw it
Yes.
onto the rooftop of Raju Ali.
Gradually, yes, ma'am.
The interview will be
So,
difficult.
from his position, my lord,
Let's see the case diary.
Lordship,
If you want, I can fix it on,
in
we can fix it on 2nd July also, if you are available during the vacation,
Lordship, after this,
after this.
Lordship, interim maybe
Interim will be difficult because there is direct implication. He is actually the main implicated person, according to
that is a
that.
concocted story by police. Lordship.
Let us see. All for the case diary of Romania PS case number. What is the case number?
160/26.
160/26.
Romania PS case number 160/2026. So. The gist of the allegations in the FIR dated 17/6/2026 is that the police party, upon getting information about peddling of heroin by petitioner Moon Ali, went to the stated location. And it is alleged that upon noticing arrival of the police party, the said Moon Ali threw a black colored polythene onto the roof of a neighboring person, Raju Ali, and jumped from the rooftop and fled away first. During subsequent search, the polythene packet was recovered and it was found to contain 97 plastic vials containing suspected heroin, which were later weighed and found to be 10.63 grams, excluding the containers. The learned counsel submits that the petitioner has been falsely implicated. List the matter on.
16/7.
Is it okay? Or do you want it earlier? 16/7?
16/7.
16.
16.
Right.
Bad case loss. So in this case, my the petitioner is my lord assistant manager of my lord Axis Bank locking not locking for lordship. Now the in 2024, my lord, the allegation is my lord a complaint was lodged by the bank, my lord, against the management of that branch lordship. In that case, I am accused number 2. My lord, say allegation is main allegation is
FIR is dated,
at page 9 lordship. The affair is type copy is there. Lordship.
page 9.
Yes, lord.
And the original copy is that?
Original as a 22 loss. This is a as that is why it was typed out loss. My lord, I am accused number 2, assistant manager loss. Others are my lord staffs of manager lordship. One is my lord public relation officer, my lord. His duty is to verify the genuineness of the my lord borrower's lordship. My lord, accused number 1, my lord.
Okay.
My lord, this honorable court lordship.
He's mentioned as number 2. Huh?
Yes, lordship. He is assistant manager, lordship. His duty is my lord disburse my lord distribution of the my lord duties of the my lord.
What is the
Employees.
allegation? Fraudulent grant loans.
My lord, this is
Sir, fraudulent giving of loans.
yes, lordship. My lord.
Long affair.
Earlier, your lordship has told that one accused petitioner initially rejected my lord.
Can we seek the case diary?
Now, for a moment,
You
lordship,
want-
kindly
if
seek-
you-
lordship,
If
for a
you're
moment,
seeking
kindly seek
interim,
case-
then you submit.
My lord, for a moment, 37 loss. Yes, 37. You lordship granted bail lordship, absolute bail to the accused number 1 lordship.
Regarding accused number 1,
Yes.
initially your lordship was pleased to reject, my lord.
Yes,
later on,
second
my
time it was granted lordship. Now kindly see paragraph my lord, at page 37 loss. You lordship granted bail lordship.
37.
Page 37.
Yes, I've seen. Found it.
My lord,
economic offense, my lord, bank has, my lord.
paragraph 7 onwards lordship, kindly see. The submission was considered lordship and your lordship.
He was dismissed from service also.
My lord, I am already, my lord,
not dismissed, Lordship. My lord,
Talking.
proceeding, my lord, the departmental proceeding is going on. I'm suspended. I have already been suspended. I cannot exceed to which, my lord, is documentary evidence is clear, Lordship. Already, my lord, 2 years, my lord, has gone, my lord, progress of investigation is there. On the basis, considering the progress of investigation, the accused number 1 was granted bail, Lordship. So, if interim is granted, Lordship, I will appear before the IO, Lordship. My lord, the investigation will also be progressed, Lordship. As I have already been suspended, Lordship, that was also considered in earlier case, Lordship, in other case, Lordship. So in my humble submission, I may be protected. I will appear before the IO and cooperate with the investigation, Lordship. If, my lord, in the C case, there is something comes against me, that will be subject to, my lord, decision, final decision of your Lordship.
Purity cannot be a ground, my lord, for consideration of bail in this case. There is huge financial loss, my lord.
That is correct, but main accused was Jan. He was the accused number 1, Lordship. My lord, the public relation officer is the, my lord,
We
responsible.
can fix it on 2nd.
Yes.
And see the case diary within a week.
Till then, Lordship.
If you are available, if you are
Lordship,
available. Because of
suspended. Lordship.
councils also go somewhere during the vacation. Mr. M. H. Ahmed, learned counsel for the petition. You can, para 38, third paragraph, you can leave it. Learned counsel submits that that with regard to a co-accused, namely Gopinath Stonewal, his subsequent bail application was application for pre-arrest bail was accepted by this court, and considering the progress of investigation, he was granted bail by the order dated 11/6/2026 in AB 1012 of 2026. Also, it is submitted that the petitioner has already been suspended and it's facing domestic inquiry, and if granted interim, he shall appear and render full cooperation. However, at this stage, I deem it proper to only call for the case diary, which is also submitted to by the learned additional people. So date, should it be 2nd or after reopening?
After reopening, my lord, if I am for protected, Lordship, I will be
No,
clear, Lord.
14,
14, sir.
immediately after. These bank fraud cases, we have to be
Till
little
then,
careful.
Till
Careful.
then, Lordship.
No, only from 14th.
Okay.
May please your lordships. For the BNSS application lordships, FIR lordships will find it page 11 lordships. The vernacular FIR lordships. May read the FIR lordships.
Cattle,
Page number 11.
page 11.
May read the.
You read that. অসমীয়া you read.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি দুপৰীয়া প্ৰায় 3মান বজাত মই পেট্ৰলিং দলৰ কৰ্মচাৰীসকলৰ সৈতে নিয়মীয়া টহলদাৰী কৰ্তব্য পালন কৰি থকা অৱস্থাত S12P6309 নম্বৰ এখন প্ৰাকক্ষেত্ৰী কেন্দ্ৰবামত NH27 সোঁফালে লেনত ৰৈ থকা অৱস্থাত দেখা পাওঁ। আমি ট্ৰাকখনৰ ফালে আগবাঢ়ি যোৱা দেখি চালকজন পলাই যায়। ট্ৰাকৰ পিছফালে উঠি চোৱাত বহুতো গৰু পোৱা যায়। সন্দেহ হয় যে উক্ত গৰুবোৰ ট্ৰাকখনৰ চালক, মালিক আৰু অন্যান্য চোৰাং গৰুৰ সৰবৰাহকাৰী লগ হৈ চুৰি গৰুসমূহ অতি নিষ্ঠুৰভাৱে ঘনকৈ কঢ়িয়াই আনি সেইবোৰ বহিৰাজ্যলৈ প্ৰেৰণ কৰিবৰ চেষ্টা চলাইছিল। ইয়াৰ পিছত SI টিকেন ডেকা ঘটনাস্থলীত উপস্থিত হৈ আইন অনুসৰি উক্ত ট্ৰাকখন মুঠ 54টা গৰু জব্দ কৰে। This is the FIR lawsuit and the case was registered under section 3032 3172 BNS lawsuit. Read with section 11(1) ADE B of Prevention of Cruelty to Animals Act and read with section 13(1) Assam Cattle Preservation Act. The present petitioner, there are two petitioners before lawsuits. Petition number 1 is the owner of the cattle lawsuit. I have annexed the cattle purchase receipt. The lawsuit will find a page number lawsuits 18 onwards lawsuit, page number 18 onwards. On Saidul Islam is the owner of the cattle. He has purchased the said cattle from the Rajmai cattle market from the Shivsagar lawsuit. Page number 18 your lawsuit got it. Page number 18 onwards lawsuits. All the cattle purchase receipt I have annexed lawsuits. He has purchased said cattle from the Rajmai Shivsagar lawsuits. And he is carrying the said cattle to his house from Mayang, Morrigaon district lawsuit. And driver wrongly crossed he cannot look at the Mayang road lawsuit, so he parked the vehicle at the Kendogam lawsuit. In the meantime, the police personnel released lawsuit and the said cattle were seized lawsuit.
And
In the lawsuit,
what about petitioner number 2?
Petitioner 2 is the owner of the vehicle lawsuit.
Vehicle.
Lawsuit. So my humble submission before lawsuit, let them appear before the IO with these documents lawsuit. So I will verify and lawsuit If there any discrepancies found, also, your lordship may reject my prayer, lordship. That's my humble submission. lordship.
Okay. I accept that.
Well, only 6 numbers of my lord kettles can be carried in and goods carrying.
That's
That is
true.
12, 12 is available.
54
No,
numbers.
that's 54.
54 numbers.
That is 12, 12 can be available, offense, lordship.
No, but still, should not,
All offenses are non-violent.
these laws are made for a reason. And
Yes.
all living beings need compassion
No.
and kindness.
No, this is
And
lordship.
unnecessarily, all these documents,
Yeah,
he has annexed from a
Lots of-
particular market, who will verify these documents?
Animal cruelty.
Genuineness
is
of
a
Correct. Animal
important
cruelty
law.
is, animal cruelty is available, offense,
Where
lordship.
is your license?
Section 11, lordship.
Don't go into that. I'm giving interim. Don't
Lots.
go into that bay level aspect.
No.
It's a very old act.
Lordship. No, lordship, the Assam Cattle Preservation, your lordship, well aware that if the cattle is purchased from the registered market, lordship, then no permission is required to carry cattle from one district to another. Subject to the provision that, lordship, the cattle cannot be
No, if-
transported to
if-
those districts, lordship, where
If my
international border is
lord,
sharing.
if my lord bailable offense, then my lord, this anticipatory bail petition is not maintainable. my lord.
No, Section
If he wants
13,
to-
they have added, Section 13, lordship, they.
Record your statement, but
Yes,
could
sir.
justify
Let them
that
appear,
with
let them appear.
six, instead of 654 people,
Yes.
the
Yes.
54 living beings.
Yes.
Right.
See it like that. Yeah,
So, my lord, how in a cruel manner, my lord?
that we should not commit crime. A person who's compassionate to animals is likely to be a generally compassionate person also.
Yes,
So that is why these are spirit of these laws.
yes.
actually. Uh, Mr. T. Chudia, learned counsel for the petitioner. 482 BNS, K3 PS case number 52 of 2027, section. Full stop. The allegation in the FIR was that a truck was apprehended, which were found to be carrying large number of cattle in cruel conditions. Full stop. The petitioner number 1 is stated to be the owner of the cattle, and learned counsel has drawn the attention of this court to the annexed receipts pertaining to the purported purchase of the said cattle from Rajmai Weekly Cattle Market. Full stop. The petitioner number 2 is stated to be the owner of the vehicle bearing registration number. What is the number of the vehicle? AS 12 E6309 within bracket truck. Full stop. Learned counsel seeking interim bail submits that they shall appear before the IO. They are willing to appear before the IO with all the documents in support of their position. Learned additional PP points out that as per the Cattle Preservation Act of Assam, only 6 cattle can be.
No, it is not about Assam Cattle Preservation, lordship. This is wrongly submitted, lordship. It is about the prevention of cruelty to animals act, lordship, animals rule.
The large number of cattle were carried in the truck in the were allegedly carried in the truck in the incident situation, much beyond the permissible limits. Full stop. Nevertheless, call for the case diary. However, in the interim, in the event of the arrest, 50,000 with 1 security each, with the satisfaction of the arresting authority, subject to the conditions. Cooperate with the investigation. Number 2, they shall appear before the IO for examination. Shall not hamper or tamper evidence. Number 4, shall not violate any provisions of the Cattle Preservation Act and prevention of cruelty to lift it from there to the act. Full stop. This is the matter on
27, 20.
All right, lordship. Okay.
FIR, your lordship will find page 14, lordship. May I read it? বিনীত সন্মানপূৰ্বক নিবেদন এই যে আজি ইংৰাজী 1/6/2026 তাৰিখে দিনৰ 1:25 AS Swenson গাড়ী দুখনে ড্ৰামত 1825 লিটাৰ ডিজেল ভৰাই উক্ত ডিজেলৰ টকা পইচা নিদিয়াকৈ আমাৰ অজ্ঞাতে পলাই গৈছে। ডিজেলৰ মূল্য 1,19,507 টকা। So গ্ৰাহকৰ নাম সুমিত কুমাৰ। So petitioner of your lordship is Navajyoti Hazarika. He is just friend of that FIR name accused. And the allegation is that after taking those 18,025 liter diesel without paying money, they left. Now, lordship, if your lordship turns to page 15, this is the forwarding report of other accused persons who were lordship arrested And already all those articles were recovered, Lordship. Page 16 is the grounds of arrest. Your Lordship will find that it was kept in the storage of those persons, Lordship. Ground number 2. Ground number 1, during the course of investigation, it is ascertained that the above named mentioned accused persons were in possession of and had stored substantial quantities of suspected petroleum products in a dilapidated bamboo and tin structure situated near BG Road, adjoining the ONGC boundary wall at Shivsagar. Investigation led to the recovery of barrels containing suspected diesel believed to have been unlawfully obtained from the complainant's petrol pump from the aforesaid premises. So those are the which were taken from the petrol pump, Lordship. And now if your Lordship turns to page 18,
He is not named.
he is not named, Lordship. He is friend of that FIR name 18.
Some associates they have said.
Lord. That page 18 is the order dated 16/6/26, Lordship. And here your Lordship will find in the last paragraph of page 18, then around 1800 liters, that is Lordship, 25 liter less than the alleged quantity mentioned in the FIR. That is already given Jimma to the person, Lordship, recovered and given Jimma
To the depot.
to the depot, Lordship. And non-payment of money already, those articles were recovered, given Jimma to owner, and he is not named in the FIR. If anything is there, he will cooperate, Lordship.
Yeah, Amit.
Your Lordship, that is the my
Anything else?
FIR initial stages. My Your Lordship may kindly come to page 16, my lord. Page 16, my lord, ground number 4 and 5, my lord. This is
Page
the
16.
page 16, my lord. Already he has pointed out.
Yes,
my lord.
yes.
Ground number 4, my lord, and 5.
Wide network.
Yes, yes.
That I told you, associates.
Yes.
He may come in associates, but we
Yes.
don't know.
Yes.
Let him record the statement. Prima facie, it is not there. 482. Sipsagar PS case 102 of 2026. The gist of the allegations in the FIR dated 2/6. FIR is dated 2/6.
Lordship.
1/6. 1/6/2026. Is that the accused persons named in the FIR after taking large quantity of diesel from the informant's pump, played away without paying any money. And the amount was rupees 1,79,507. Both the FIR name accused persons were arrested.
FIR name accused person was arrested. The person with whom the articles were deposited, that those two persons were arrested. Page 15,
2 vehicles.
Lordship.
No, you say not FIR name persons, 2 vehicles. Fill the total of so and so and fled away without making payment. 2 vehicles, not persons, are not them. Subsequently, it is stated that as per the forwarding report, subsequently, the vehicles were the diesel was seized from the possession of 2 persons who were arrested. It is stated in the forwarding report, as pointed out by the learned additional people, that the police suspect the involvement of network and that some associates of the arrested persons may also be involved in illegally transacting in high-speed diesel. Mr. Ahmed submits that the petitioner is not named in FIR nor in the forwarding report, full stop. It is also submitted drawing attention to order dated 16/6/2026 passed by the learned CJM Sivasagar that that 1800 liters of this diesel have already been recovered and seized and kept in the premises of the police station. In the situation,
Those were given Jimma to the owner, Lordship.
and also given Jimma to the owner. In the circumstances, accepting the prayer for interim bail, it is directed in the interim 50,000 security. Operate, appear before IO, not hamper or temporary dealings. List on 29,
Yes, ma'am.
29/7.
Obliged.
May I please do, Lordship? So in this case, FIR, translated copy of the FIR at page number 9, Lordship. Petitioner is a trustee of a rehab center, Lordship.
Just a moment. 59 supply.
Page 9 is it translated to vernacular copy, Lordship, page 14. Petitioner is
You
a
can, you want to read the vernacular copy? You can read the vernacular
Lordship.
if you have no discount, if you are comfortable. Right.
Petitioner is the accused number 2 in the FIR, Lordship.
Akla Hussain.
Alias Bubbling, Lordship, accused number 2. But in the Lordship, kindly go through the FIR, Lordship.
Yes.
সম্মানপূর্বক সহকারে জানা যে উক্ত 1 নং আসামিজন জুরিয়া উইশ ওয়েলফেয়ার ফাউন্ডেশন রিহেবিলিটেশন সেন্টারও হত্যাধিকারী হয়। মূল ল'ৰা মাজহাৰুল ইছলাম ড্ৰাগছ আসক্ত হোৱাৰ বাবে যোৱা ফেব্ৰুৱাৰী মাহত উক্ত ৰিহেবিলিটেশন চেণ্টাৰত দিছিলোঁ। পিছত জানিব পাৰো যে ৰিহেব চেণ্টাৰখনে কোনো ধৰণৰ চৰকাৰী নীতি নিৰ্দেশনা আৰু ৰিহেবিলিটেশন চেণ্টাৰৰ গাইডলাইন মতে ৰিহেব চেণ্টাৰটো পৰিচালনা নকৰে। আনকি উক্ত ৰিহেব চেণ্টাৰটোত কোনো ডক্টৰ নাৰ্ছৰ ব্যৱস্থা নাই। ৰিহেব চেণ্টাৰটোৰ নামত ড্ৰাগছ আসক্ত পৰিয়ালৰ পৰা নানা ধৰণৰ প্ৰতাৰণা কৰি ধন দাবী কৰি টকা লয়। এজাহাৰত উপৰোক্ত উল্লেখিত আন আসামী কেইজনে উক্ত ৰিহেব চেণ্টাৰটোত হত্যাধিকাৰী হয়। যোৱা ইংৰাজী 31/5/2026 তাৰিখ অনুমানিক 8টা মান বজাত মোৰ ল'ৰা মাজহাৰুল ইছলামক উক্ত 1 নং আসামীজনে লৈছিল। এলিগেশ্যন এগেইনষ্ট দি নাম্বাৰ 1 একিউজ। আসামীজনে প্ৰচণ্ড মাৰপিট কৰি এখন বৰি ভাঙি দিয়ে আৰু বৰ্তমানে উক্ত ৰিহেব চেণ্টাৰত আবদ্ধ কৰি ৰাখিছে। তদুপৰি আন এজন ড্ৰাগছ আসক্ত ব্যক্তি সহেঞ্চ আলিক প্ৰচণ্ড মাৰপিট কৰি উপৰোক্ত গুৰুতৰ জখম কৰিছে আৰু উক্ত ৰিহেব চেণ্টাৰটোত আবদ্ধ কৰি ৰাখিছে। উক্ত আসামী কেইজনে মাৰপিট কৰা সময়ত ৰিহেব চেণ্টাৰটোত CCTV কেমেৰা বন্ধ কৰি লয়। This is the allegation, Lordship, against the accused number 1. Accordingly, he was arrested, Lordship. Till now, he is behind the bar, Lordship. I am the accused number 2 in the. I am only my connection in this case, Lordship. I am the trustee. The document is
The second boy was also beaten up by.
No, Lordship, he was not appeared. He did not present that time, Lordship, in the incident time.
No, I'm saying the second victim, alleged victim.
Oh, second victim.
Prochanda marpit kore, but he has not said who has beaten.
Who has been, Lordship? But I am not present.
You are
I
the
am only
trustee of this.
trustee, Lordship. I am just trustee. Page 17, Lordship. This is the type copy of our deed trust document, Lordship. Vernacular copy, Lordship, page 24. This is a registered trust, Lordship. I am trustee. My name is there, Lordship, in Akhlaq sign. There's bubbling, Lordship. So city may be called for, Lordship. In the meantime, I may be protect, Lordship. I was not present at the incident time. One of the staff, Lordship, beaten the victim, Lordship.
Physical torture continuously going on all these rehab centers recently. And here also,
Oh, really?
yes.
And it's not easy to run a drug rehab
Yes,
center.
yes.
You need,
Yes, sir. Something
it's
is-
very difficult.
Very-
But anyway,
I am the trustee, Lordship. This is the only. There are
And
no
there's no allegation of assault against him,
against him.
it seems.
Yes, yes. Regarding the present petitioner, ek nong Assami zone, ek number Assami zone.
Be fair to.
name is Abu Jamal. One
Accept,
Abu Jamal.
let him record his statement. But I mean, he should, as a trustee, he should also
In some,
have overall responsibility.
in some of the rehab centers, also recently, death also occurred due to all
They
these.
are always vulnerable to death.
Death.
People who are very much into addiction, but still, when the state support is also weak, actually. Anyway. Invoking 483, the petitioner is seeking anticipatory bail in connection with Juria PS case number 137 also. The Lord Council has taken the court through the fire dated 2/6/2026, wherein 5 persons have been named, including the present petitioner as A2. The allegations is that those persons are running the Juria Wish Welfare Foundation Rehabilitation Center for rehabilitation of drug afflicted persons. It is alleged that the center has been run without any support of doctors and nurse. It is also alleged that on 31/5/2026, the accused number 1 assaulted one inmate, causing injuries. And that another inmate was also assaulted and kept in the state center. full stop. The Learned Counsel submits that the petitioner herein, within bracket A2, is only a trustee of the said center, and there is also no allegation of assault against him. The Learned Counsel has drawn my attention to the annex documents pertaining to the trust. Call for the case diary. However, in the interim, 30,000. One security satisfaction. Cooperate with the investigation, for examination, not hamper or temper. List on
29.7.
29.7. Okay.
Number 50 is.
Made it clear, the FIR is at page 13, madam. This is in type copy and the vernacular is at page 17, madam. But actually, what had happened, vernacular is just so small, madam, in size. That's why I have typed it, madam. May I read, madam? The complainant Sri Shubhodip Dasgupta is it about so and so? Well, this is his address and everything. At never so and so.
Petitioner, this is one petitioner, right? Roton.
Yes, but he is not the name accused in this case. In this complaint, it was stated that ICICI Lombard General Insurance Company received a court notice along with a copy of the petition bearing number so and so MSCT code Boingao. Pursuant to this, the company initiated a verification process to ascertain the authenticity of the case details. During the course of verification, it was observed that as per the general diary entry so and so, the vehicle involved in the accident was recorded as AS 15A 4510. Whereas in the FIR, the vehicle number was mentioned at AS 19A0349. It was further noted that the FIR was lost after a delay of 42 days. Copies of the FIR and the relevant GD entry were enclosed as annexure affixed. Upon verification, it was prima facie concluded that the claimant had fraudulently misrepresented the actual facts of the accident and falsely implicated the vehicle bearing registration number AS 19H0349, which is insured with ICICI Lombard GIC with the intention of obtaining the undue compensation from the insurance company. Accordingly, a request was made for conducting a detailed inquiry into the said accident case. On receipt of the complaint from ICICI Lombard, an inquiry was initiated by number so and so dated 4/2/2026. Under the supervision of the SIT, the inquiry was conducted by Inspector Deepak Shokia of CID Assam, who subsequently submitted his report, where it reveals that significant discrepancies were found regarding the registration number of the motorcycle involved as reflected in the GD entries, FIR and the other case record. The findings clearly indicate that the miscreant fabricated the evidence and fraudulently used such fabricated documents before the Honorable Court with the intent to obtain the undue compensation from the insurance company. Accordingly, CIDPS case number so and so has been registered under section so and so, hence this case. But this FIR has been registered pursuant to an purported complaint lodged by the ICICI company. Well, page 21, kindly please. This complaint has been filed in the month of September 2025. The same content has been made in this complaint as has been made in the FIR. But what had happened? Page 21. Page 21. We are the company raised, got it? Page 21.
Who's the petitioner?
Petitioner is the IO in that case.
IO?
Yes. Well, kindly see page 21. Got it?
Yes. Yes.
We are the company registered under the Companies Act 1956 and engaged in the activity of the providing general insurance in the name and style of the ICICI Lombard so and so, and having its registered office at so and so one. We would like to state that the company has been served upon with the court notice along with the petition copy bearing number so and so through Motor Accident Claim Tribunal at Boingao. These are the details of given. Immediately upon receipt of the aforesaid court petition, the company initiated the verification to ascertain the genuineness of the aforesaid details. Accordingly, during the verification, it is observed that as per same day, that is GD entry number so and so, the accused vehicle is AS 16A4510, whereas as per the FIR, accused vehicle is AS 19A0349. FIR is lost after a delay of 42 days. We hereby enclose copy of the said FIR GD entry so and so for ready reference. That it can be easily concluded that the claimant had fraudulently misrepresented the actual facts of the accident and implanted the vehicle bearing registration number so and so insured by ICI Lombard to grab the undue compensation from the insurance company. In the light of formation of the SIT, it is the Assam of the pursuant of the order dated so and so, the Honorable Supreme Court of India passed a special leave petition in so and so, so and so. In so and so case, you are requested to kindly consider the present application towards inquiry in accident case bearing criminal case number so and so. But in fact, Malad, this complaint has been lost in September 2025. The MAC case, which has already been disposed of in the year 2021, Malad. And the same complaint has been raised before the tribunal. Malad, kindly come to the page 23, Malad. This is the judgment.
The MAC matter was disposed of on the basis of the GD entry registration number or the FIR registration number?
The FIR registration number, but the GD entry registration number, that very complaint have raised before the tribunal also. And tribunal, after taking the evidences, and concluded, just came to the para 12 of the judgment, page 37, page 37 of judgment. That is clarified. The opposite party number 1, that is the insurance company, adduced evidence stating that the alleged vehicle was not involved in the accident and the vehicle involved in the accident as AS 16A4510, which was not insured with the opposite party number 1, but with DW2, the IO, that is the present petitioner before your lordship, of the said accident. In evidence clearly stated that the vehicle bearing registration number so and so was brought from the place of occurrence on assumption, and stated that later on he learned the truth and finding the prima facie case involving the vehicle bearing registration number so and so seized the vehicle and had done the mechanical examination on the vehicle. Later on, charge sheet exhibit 3 was filed against the driver and vehicle bearing registration number 19H0349. DW2 also stated that the vehicle number recorded in GD entry was wrong. Moreover, DW1, that is the insurance company, stated that the investigator told that the driver of the vehicle informed him that he did not drive the vehicle involved in the accident, but he had not submitted the report of the investigator before this court, including the statement of the driver and the owner of the vehicle. From the above, it is concluded that the accident was occurred involving the vehicle bearing registration number AS 19H0349, and the charge sheet was filed against the opposite party number 3, that is the driver vehicle bearing registration number so and so. But interestingly, in the complaint as well as FIR, not a single whisper has been made regarding the disposal of the MSC case, since that has been contested by the insurance company. And the same complaint has raised before the tribunal. The tribunal has, after taking the additional, the eyewitness is also there. That has been recorded by the learned tribunal. That is at page 33. That is the eyewitness, PW2, page 33. PW2 Bipul Shah claimed to be the eyewitness of the accident. He stated that on 7/7/2015 at about yes.
Anyway.
Yes, yes, otherwise, he is the IO of that motor accident case. The allegation is that he has changed the
number. Did not have insurance, so this was placed.
Yes. Ultimately, insurance, there is finding of the in that insurance case also.
These things happen very commonly.
Yes.
How many hit and run cases do you find? Do you find?
Yes.
Why? Many accidents are hit and run actually, but
yes,
vehicles are just they're created anyway. So you'll not get arrested. These are police officers. Yes. So let it be only case there is this case.
Yes, and everything has already been on record. That has been seized. And but it is interesting that in the complaint they have not made a single whisper intentionally that that case has been disposed of earlier in the year 2021.
So learned counsel for the petitioner Islam and P. Potak. What do you say, Mr. Potak? Call for the case diary of this was registered as a CID case, right?
Yes,
CID case number, because the SIT is there now. Supreme, in terms of Supreme Court decision. CID PS case number 4 of 2026 under section. the FIR was lodged on behalf of the ICICI Lombard General Insurance Company with the allegations that with regard to a claim case pertaining to an accident, it was found that same day GD being GD number 334 dated 7/7/25, the vehicle is indicated as AS 16A4510. Whereas as per the FIR accused vehicle, the FIR, as per the FIR, the offending vehicle is AS 19H0349. It is also alleged that it is also stated that the FIR was lost after a delay of 42 days. Full stop. It is alleged that fraudulent misrepresentation was done with regard to the accident by planting a false vehicle being AS 19H0349, insured by the ICICI Lombard to grab undue compensation for the insurance. On the basis of the complaint from the insurance company, the instant case was registered. The present petitioner is stated to be the IO of the which was the accident case?
The accident case number
Here, it was IO of the case which was registered pertaining to the accident. Full stop. The claims tribunal, it has disposed of the claim.
yes,
Compensation was awarded.
yes, awarded.
The claims tribunal
Yes,
disposed of the claims proceeding, awarding a total compensation of 26,77,358. Full stop. Along with 6% interest. Full stop. In the context of the allegation, full stop. If the allegations made by the insurance company are true about impersonating the vehicle involved in the accident, it would amount to playing fraud on the tribunal also. Full stop. At this stage, call for the case diary of so and so CD. Fix a date.
On my lord, 37/30.
Okay.
yes. But in the meantime, my lord,
No interim.
my lord, here in this case, my lord, can we see?
No, the prayer for interim. No, I cannot grant it. These are huge modus operandi. Let it be investigated.
Well, then, my lord, a short date may be given then.
No, the prayer for interim is rejected at this stage, considering the nature of the allegations and the possible investigation into the angle of fraud and misrepresentation.
On 21/7.
Because tribunal has given award.
Then, my lord, I am not pressing the interim, my lord, then simply the CD may be fixed.
Got it. Listen.
My lord, the date,
So sometimes
a short date may
the
be.
client also expects, no? That
Yes, my lord. Earlier date may.
I requested you did not even pray
Yes,
that for interim. So he should not misunderstand. But if the council requests, we'll remove.
yes, yes. My lord, a date may be. My lord.
Yes, take your date. Please understand, let the
20,
investigation.
20
He'll not be arrested.
Yes,
That's what I was saying. He's a
20
police officer who will investigate.
20
My lord, he is the retired police officer.
They are not arrested. Even more than they will not arrest. Yes,
20.
fraternity.
21/7.
21. Months.
Bail hearing be at 23-24.
Because these things also, affect lawyers also, not the image of lawyers also.
23 and 24, your lordship has expressed to take up these matters at 2 minutes.
Together. Okay, so those matters.
Then
36 matter, my lord.
And all the analogous matters we can take up at 2.
2 minutes.
Until 1, we can finish as many of the other
23,
matters as
24
possible.
and 25 also, my lord.
52, my lord, 52 is also supplementary list, 52 is also similar, my lord.
Both sides have to guide on one aspect that if it is referred, it seems if it is referred to larger bench,
Yes.
not larger, I don't refer, I said before Chief Justice, Honorable Chief Justice, then what happens to the bail in between, in the
Yes.
meantime, because that may take some time.
Yes.
Application is also there, it may take some time, 1 month it will take, probably, at the very least. So think about that aspect.
Supply 52 is the similar issue, my lord.
Just 5 minutes.
25 is also, my lord, same point regarding 36 or 30.
36 and 48 also, my lord. Accused signature is not there.
Same point,
Yes, your lordship may kindly take it.
just make a list of those matters
Yes, ma'am.
and we'll take it up together, it'll save time also. Because the points are common.
Yes. Two. So 25, 23, 24, 25. বাকি এটা কোন list এখন বানাই দিচ্ছি।
Ah,
The file of the-
do that, huh? The main, okay. We'll finish whatever we can.
Wait, please, your lordship. Here in this case, the petitioner is in custody since 26/1/2026. And charge sheeted matter. Here I am taking your lordship to page 27, lordship, that is the notice under section 48. Here no signature of family members is there, lordship, and my case is that no notice was served to the family members. And in fact, lordship, in
It was
the
generated but not served.
not served, and in fact, if your lordship sees in the top portion, it is mentioned that police station, Badarpur police station, but to whom it is addressed, that is not there. Who is the nominated person to be served, lordship? That has to be there, otherwise how they will serve, lordship? If a notice is sent to a particular police station, lordship, it has to be mentioned that to whom it is required to be served.
Okay, number page.
26.
Please guide.
Yes, madam. Otherwise, one WT message is there in the record, madam.
Sending of WT message will probably not serve, okay? They have to say, lordship, that when that WT message was served to the family members.
Okay.
They may issue that WT message.
It can be sent
Yes,
electronically.
that can be sent, but they have to even then they have to say that subsequently it was served to the family members. That noting has to be there, lordship.
Murshidabad district of West Bengal,
Lord.
from Badarpur. Lots of, large number of Yaba tablets.
Yes, 4,000 Yaba tablets for 450 grams. Huge quantity.
So what do you say? Will it suffice? It's not addressed to anyone. The WT message is there. Doubtful.
No.
Avoid.
That is arrested only on 26/1/26. Arrested on 26/1/26.
It's doubtful, no? It's not suffice. I don't think it'll suffice. But they have narrated. Content is there. Conveyance is not there.
Yes.
Anyway, they Ahmed learned counsel for the petition. And the petitioner invoking 483 BNS is seeking regular bail connection with special NDPS case number 35 of 2026 arising out of Badarpur PS case number 10 of 2026 under so Act. The allegation was about recovery of large number of psychotropic substances by way of suspected Yaba tablets from the apprehended accused person. He is Abdul Halim only. Apprehended accused person, the petitioner herein. Full stop. He was arrested on. Give me the date. 26/1/2026. Full stop. The case was charge sheeted after completion of investigation. Presently, at the stage of trial.
Lordship.
At the stage of trial. Full stop.
The charges yet to be framed, lordship.
Presently reached the stage of trial.
14/7. Fixed on.
And presently pending for consideration of charge. Full stop.
Only one that earlier that round they have not raised before the trial court.
At the outset, Mr. Ahmed Lanet Counsel has drawn attention, has taken this court to copy of the notice under 48 BNSS annexed with the petition and submitted that it is not addressed to any particular person and does not bear the signature of any family member or nominated person. Upon perusing the notice, I find that it narrates in sufficient detail the brief of the case and the grounds of arrest. Full stop. However, it is true that it is not addressed to any person, nor does it bear any signature. The scan record is available from which the prosecution points out the WT message regarding the said notice under 48 VNSS sent to the OC Suti PS in Murshidabad district of West Bengal. The Badarpur police has made the effort to narrate the grounds in the notice under 48 and also send the WT message, but the said compliance still falls short of the requirement still falls short of the constitutional requirement and the laws laid thereunder. Constitutional requirement under Article 22 and the laws laid thereunder by the Honorable Supreme Court, in bracket, reference Vihan Kumar. Full stop. The IO is required to gather some materials about conveying of the notice to nominated person or family member, and in the event of refusal, get an endorsement regarding the same. Such procedural aspects need to be followed scrupulously, especially in serious cases like the instant one, having significant bearing on society. In the instant case, in view of the finding that the aforesaid compliance is inadequate and would not meet the requisite standards, the further under trial detention of the petitioner has to be interfered with in this bail petition. Accordingly, 1 lakh with 1 security of like amount. Two securities, two securities, West Bengal, one of whom should be from the state of Assam. Conditions: he shall not abscond. He shall be available for trial if on offense. He shall not hamper or tamper the evidence, including refrain from committing any illegal activities under the NDPS Act. A copy of this order shall be furnished. In all such cases, we'll do that.
Yes, my lord, otherwise my one prayer with your lordship, my lord, a direction may be issued to make an inquiry, my lord, as to why there is notice, my lord, in the notice, my lord, 48, there is no address, my lord, to whom the notice has to be served, my lord. Regarding that, my lord, your lordship. If there is
Direction.
yes, one.
General direction.
Yes, in 48 notice, my lord, my lord.
I mentioned actually.
Yes,
But I will, a copy of all these things will do this standard. A copy
Because
of
in the
this order
48 notice, my
shall
lord,
be
to whom-
furnished.
Because this is, my lord,
Yes, yes.
peculiar, to whom
They have to
that
take
notice
care.
has to be served, my lord.
They have to take care.
That
The
address is not there, my lord.
Learned
Huge
additional
quantity of
PP
patra-
submits that it is very necessary for the
4,000.
might low. The learned additional PP submits at this stage that it is very necessary for the police of investigating officers to address the notice properly.
Yes,
Ad-
well, there
address
is no
such
address,
notices
in fact,
properly.
to whom the, my lord, 48 notice has
Ah,
to be served.
Yes. Full stop.
Huge quantity of, my
Yes,
lord,
a copy of this order
4,000.
shall be furnished to the learned additional PP for onward transmission to the learned SP of Badarpur would be which?
Yes, sir,
Shribhumi. Learned SP. You have to keep them in the loop. Really.
27.
Take it off. Really.
Statement to secure item. Disclaimer statement to secure item. I say. Evidence to. 7 victim to have the
This one also, same.
No, my lord, this is a POXO case, my lord. POXO, my lord, section 6 of the POXO Act, my lord. The evidence of the informant and the victim has been recorded, my lord. And the petitioner is in custody for 202 days, my lord. The lordship will kindly see the FIR. So lordship will find that page number 14, my lord.
Page number
14, my lord.
14.
I'm not reading it out, my lord, because POXO is there, my lord.
No, it's okay. I've gone through it.
My lord. No, my lord will kindly see one thing. In the original FIR at page 20, the informant puts his thumb impression there.
And now if you also will kindly come to the evidence of the informant, my lord, at page 35.
Yes. This is the evidence of the informant.
In the evidence of the informant, my lord. So here he renounces the fact that this FIR, the contents of the FIR were written by him, my lord.
Anyway.
And now if your lordship will kindly just for a moment, my lord, will kindly come to page 6, my lord, page 6 of our petition, my lord. Our contentions, my lord. From para 11, my lord.
Yes. Yes.
May I read, my lord. The accused petitioner most humbly submits that the prosecution's narrative is marked by material omissions and fails to disclose the true factual background of the case. It is submitted that the informant is the petitioner's nephew. Following the demise of the informant's wife, that is the victim's mother, the informant requested the petitioner's family to take custody of the victim, who was then approximately 4 years old. Since then, the petitioner's family has been solely responsible for her upbringing, education, and welfare. Notably, the victim identifies the accused petitioner's son and daughter-in-law as her parental figures. The accused petitioner further submits that he has maintained a consistently paternal, and that part is the matter. Now, paragraph 2, matter. The petitioner most humbly submits that he is a respected member of the community and the former Gau Pradhan of the Dhunavari village. It is submitted that the present proceedings are the byproduct of deep-seated local political animosity stemming from the petitioner's support for his daughter-in-law's candidacy for the post of Gau Pradhan, a move that faced vehement opposition from certain village factions. The petitioner contends that these disgruntled elements instigated the local rivals to orchestrate a false and fabricated narrative to harass and defame him. The conspiracy was aimed at tarnishing the petitioner's family reputation and diminishing his social standing by convincing the informant to lodge the instant case under false pretenses. Well, now the informant himself, obviously, my lord, the lordship will not examine the merit of the case in detail, my lord. That will the trial court will decide. But this is our contention, my lord, and to an extent, my lord, the informant's evidence.
It raises
But
some
this-
doubts.
yes,
Anyway,
on
the victim's testimony is not.
That I have not annexed, but perhaps as my learned friend has pointed out, is there in the record. perhaps.
Victim mother examined mother. Here lordship already in the FIR mentioned mother she is 6 years old mother. Victim is 6 years old mother. Lordship kindly pays the her evidence mother. SPW2 mother. I have take back mother.
Name should not be written actually. It is being written.
Mine.
The only thing is that, yeah, there is.
In 180 again lordship 183 statement of the victim.
Same.
Minor, same minor. She is very much consistent minor. 6 years old child minor. She is very much consistent.
Okay. So anyway, the only question is that, yes, yeah, madam, that whether his bail can be considered now that since informant victim has been examined. That is the only question.
Very distinct statement has been recorded, Lordship, and the statement is consistent with
Yeah,
the
seems so.
your 183.
But we'll not say anything now.
At the time of incident, she was only 6 years old, your Lordship. And the informant was not declared as voter also, your Lordship, at the time of his examination. Yes.
Prosecution should have done that, my lord.
My lord, here I have the strong objection at this stage, my lord. As my lord, out of 12, my lord, only 2 witnesses examined, my lord. And some of the material witnesses are yet to be examined, my lord. And if he is released on bail, my lord, at this stage, my lord, he is threatening or tampering on the evidence, my lord. That's also, look into my
Yeah,
lord.
let's see.
Considering the age of the victim, my lord, 6 years old.
Yes, Nawaz learned counsel for the petitioner, E. Sharma, and Madam Nazneen. learned counsel for the informant. You are appearing as legal aid counsel? MX. Yeah, MX. For the petitioner, for the informant, it's on number 2, full stop. The petitioner seeking bail under 483 BNSS in connection with
Special POXO case, my lord,
special
takes 2 months.
POCSO case number 6 of 2026 under so and so section, which is pending at the stage of trial before the learned special judge Biswanath. Full stop. The case arose out of LMPS case number 82 of 25, which was charge sheet by CS number 7 of 26 dated 31/1/2026. Full stop. The petitioner was arrested on 3/12/2025, and since then he is in detention, presently in judicial custody. The learned Mr. Nawaz, learned counsel submits that in the meantime, informant and victim, minor victim stands examined. Full stop. It is also drawing attention to the relevant paragraph of the petitioner of the petition, bail petition. It is submitted that the petitioner has been falsely implicated due to some political reasons. In this context, attention is also drawn to the deposition of the informant, PW1, in which there is a statement about village pressure for lodging the FIR.
My lord, we also see the medical report, my lord, that also at page 38, my lord.
The medical report, it indicates what?
No injuries, my lord.
It is also submitted that the medical report does not indicate any injuries. I peruse the deposition of PW1 and also that of the alleged minor victim available in the scan record. Mr. Sharma, the learned additional people, strongly objects to the grant of bail at this stage, contending that other witnesses remain to be examined. Ms. Nazneen, learned amicus representing the informant, submits that the testimony, the statement of the victim girl is consistent true. It's consistent true. It is consistent from the statement before magistrate to her deposition during trial. Given my consideration to the matter, full stop. Considering the fact that the informant and most importantly the victim has been examined, and also the length of detention of the petitioner since so and so date of arrest, I'm of the considered view that perhaps he can be granted bail at this stage. In such view of the matter, 50,000 with one surety with the satisfaction. Number 1, he shall be available for remaining trial, not hamper or tamper with evidence. He shall not in any manner intimidate, harass, harm, or try to influence the informant/victim side or any witnesses. Violation of the bail condition will entail cancellation of the bail. Disposed of.
I'm deeply obliged, my lord. My lord, one line, my lord, here, although he said that, my lord, there is no any, my lord, injury mark, my lord.
He's studying the
Yes,
summation. I have not said anything.
No, my lord, here in the page 9, my lord, general examination, my lord, it was mentioned as on wall 3x1 cm scrape marks in, my lord.
Crap
That
mark.
is also- Scab is the, my lord, skin disease, my lord. Well, perhaps my lord, nothing does not know that. But it it is not necessary to know or do not. but-
CWs. That is good for her anyway.
My lord.
Anyway, so
Obliged, my lord.
28.
Similar. Ground to similar. Then, my lord, 26 also, 28 is also same, my lord.
Obliged, my lord.
it will save time because hearing on the submissions will be similar. Mark করে দিলাম। এখন list এখন লব। Give a list, huh? Give a list.
29.
In lunchtime, you can give a list, right? 29.
May please your lordship. Our regular bail petition, my lord, as on today is 59 days, my lord.
And POCSO is involved, my lord. Respondent number 2 has been served and he actually appeared, my lord, and affidavit has been filed, my lord.
You file a written
My lord, here
objection.
charge sheet submitted, my lord.
In this regard, my lord, so far the charge sheet is concerned, my lord. We have taken in instructions, my lord. The petitioner's family has applied for a certified copy of the charge sheet, my lord.
Hmm.
But they were informed that charge sheet has been returned back, my lord. Because some
Defect.
that is the facts, my lord. Today morning, I got an instruction, my lord.
But
So the
our-
matter is not.
But our information is that, my lord, charge sheet submitted, my lord, is submitted by our, my lord, from IO, my lord.
The petitioner family has applied for a certified copy, my lord. But the court was informed that charge sheet has been returned back because it is not income.
How old is the victim?
Victim is 15, as per the FIR, 15 years, 5 months at the time of, and the petitioner is 19 years old, my lord. There is a love relation between the parties, my lord. And I have stated everything, my lord, in my petition, my lord. What happened on that day, my lord.
Can we see the FIR, please?
FIR is the page number, my lord. I refer the vernacular one, my lord, page number 14.
Okay, let me read it. Our statement needed to be seen, actually. So what is your submission?
The stand of the informant has been brought on record, affidavit manner. And since the same manner that she later on told her mother, manner, about the actual incident. After lodging of the FIR, manner, she told the actual incident manner to her mother. Then manner, they came before this court.
They had a love affair.
Yes, manner. And there, it is also the.
Where is the affidavit? Okay, then we can consider. Got it, yes, got it.
And paragraph 4, my lord, it is stated that issues has been resolved between the parties, my lord, between both the families. That their marriage will be solemnized, my lord, on attaining the measure.
Romeo Juliet clause will
Yes.
apply then.
Yes.
No, that is in pipeline, but not come. Okay, we can apply the principle.
Here, I am unable to argue any, point out anything, my lord, as I have no any documents, my lord, only petition is here, my lord, as informed by the IO, my lord, the search is also already submitted, my lord.
Yes, that's true.
My
And I would have liked to start anyway, so I think we can dispose of. Because it's informant is, I don't, but the girl is not there, of course. Girl is not there.
Evidently, she was minor at the time of the incident, my lord.
Or grant some interim and call for report.
Fine.
Can be done. Anyway, let us see. Should not keep it anymore. MA, I have not counsel for the. So. E. Sharma, additional PP. So we learn it, counsel for the informant. Full stop. The petitioner was arrested on 28/4/2026 is seeking regular bail in connection with Gwalpara PS case number 65 of 2026 under so and so section. The FIR was lodged by the father of the girl, father of the alleged victim girl, alleging that the accused petitioner was trying to have a love relationship with his 15-year-old daughter, and subsequently taking advantage of a situation, he illegally entered their house and after inducing her, took her to Gauhati and committed physical relation upon her against her wishes. It is submitted by the learned additional PP that in the meantime, investigation stands completed, resulting in a charge sheet. Full stop.
My lord, 5 charge sheet number 78 of 26, dated 3/05/26.
The informant has filed an affidavit. And learned counsel for the informant supporting the affidavit contains that contains that there was indeed relationship between the girl and the petitioner, who stated to be aged 19 years. Drawing attention to para 4, it is submitted that the families have discussed and discussed the matter and decided to solemnize the marriage between the parties, between the girl and the petitioner after she attains majority. In the given facts and circumstances, considering the above aspect as well as completion of investigation, that it would be proper to grant bail to the accused at this stage. Accordingly, 30,000 with one surety. Section of number 1, he shall not hamper or temporary dividends. He shall not commit any harassment or annoyance or intimidation upon the victim girl.
My
Petition
objection may be
stands,
recorded. My
learned
objection may be
additional
recorded under
PP.
conduct who are minor at that time.
The learned additional PP submitting that the victim was a minor at the time of the incident opposes granting of bail at this stage.
Hello.
May please, your lordship. My lord, 77 days in custody, my lord. Or today also, my lord, CD is not received, I think, my lord.
CD not received today, my lord.
Allegation is regarding, my lord, gang rape and, my lord, putting something toxic substance. Or if a lordship.
Matter may fix on tomorrow, my lord. I will produce the case there from Nunmati. Otherwise, whether I will take instruction whether any search.
You want it tomorrow?
My lord.
Tomorrow?
My lord, no.
Case diary is not received. Learned additional PP submit that. He might be able to procure the case diary tomorrow. List matter 26.
My lord, obligation.
31.
No, 36 the issue of section 36 is involved here, lordship.
Same.
2 PM, lordship.
2 PM.
2 PM, lordship. Obliging.
Wait, please, your lordship. Lordship, this is a regular bail application. Here, this petitioner in jail custody for 110 days, lordship. May I take you, lordship, the FR that is on page 14, lordship?
Trial, no? Trial is going on.
Yes, lordship. Charge sheet has been submitted, lordship. Charge has been framed, lordship. May I read the FR that is on page 14, lordship? It is respectfully submitted that about 15 months ago, from the date of occurrence, the marriage between the accused person and my younger sister, namely such and such, was solemnized. But since after the marriage, the accused person inflicted mental torture upon my sister, and my sister used to tolerate the torture of the accused person. But on 6/3/2000, the accused person called on his from his mobile phone to my mobile number and informed me that my sister such and such has committed suicide by hanging inside the house. After getting information, I immediately rushed to the place of occurrence for the from Gauhati to Borpeta Road and found my sister dead in condition. As I suspected, the person has killed my sister and hanged her. According to lordship, case was registered initially 103. That is a punishment for murder, lordship. Murder, lordship. Lordship, after that, lordship, his petitioner was arrested, lordship. Forwarding report, lordship, will find on page 24, lordship.
Yes.
Page 24, kindly come the lordship, ground number 5. Only allegation, lordship. Initially, murder charge is there, but after postmortem, lordship, it is from a suicidal death, lordship. 108, lordship. Ground number 4, lordship. The victim body was taken down from the gallows without informing the police. Accused tried to hide it. That is the only allegation. That's why they suspected it is a murder, lordship. Then, lordship, after the lordship postmortem, then lordship, his approach for the bail, lordship, before the court below, that was rejected. Lordship will find on page 25, lordship. second paragraph from the bottom, Lordship, peruse the case record, it is revealed that the trial of the instant case has not yet started. The charge has not been framed in this case. Further revealed that the charge sheet has been submitted against the accused person 108, Lordship. Since charge was not framed, that's why his bail was not considered. Lordship now find the Lordship will find the postmortem report that is on page 27, Lordship. And the opinion part, Lordship, that is will find on page 30, Lordship. Page 30 is the opinion part, Lordship. NB, Lordship.
Yes.
Bottom portion, Lordship.
Just.
First point, the actual cause of death can be ascertained only on receipt of the toxicological and chemical analysis report from the DFS Kahilipada. Hanging is a suicidal in nature. The ligature mark corresponds with the hanging. The ligature mark presents over the neck in the antemortem in nature. No sign of violence, injury marks are present over the private parts of the deceased. Actual time of death is mentioned in the page 5 of the report. No other external injury. Most important, Lordship, no other external injury apart on the ligature, apart from the ligature mark hanging in present in the body of the deceased. No sign of sexual intercourse, such and such or such. This is the laws. Then, Lordship, the forensic report, Lordship, will find on page 34, Lordship.
Page 34
Lordship.
of your petition.
Yes, Lordship. Death was due to asphyxia as a result of antemortem hanging. Yes, Lordship. Asphyxia, Lordship. Result of antemortem hanging with a suicidal in nature, Lordship. Even in inquest report, Lordship, there is no mark of any violence over the body, Lordship. What happened, Lordship, on the first year, Lordship? On the forwarding report, it said, Lordship, he was not, the body was taken down, Lordship, without informing Lordship police. But, Lordship, may I take the, Lordship, 161 statement of the Joya Bormon, Lordship. She is the cousin of this victim, Lordship. She is residing with the, she is residing nearby his house, Lordship. This is house, Lordship.
Page?
That Joya, this is an LCL, Lordship.
Joya?
Joya Bormon, Lordship. No independent witness, Lordship, stated anything adverse against this petitioner, no cruelty, nothing, Lordship. There are three independent, Lordship. I am relying on 4 of them, Lordship.
Joya Bormon, the statement is very short.
Yes, short, Lordship. She was first informed, Lordship.
He has not stated anything. She has just stated that he called her to see the dead body.
Yes. Their Lordship kindly come to the Lordships, one of the independent witness, Bijit Kumar Roy, Lordship.
Bijit Kumar Roy. Charge has been framed in the meantime.
Yes, Lordship, 108, Lordship.
And witness not exactly.
No, Lordship. Only 110 days in jail custody, Lordship. Let him, Lordship, arrange his defense because, Lordship, it's a clear case of suicide, Lordship. No cruelty, nothing else, no demand of dowry, nothing else, Lordship. Actually, what happened, Lordship, this victim is a, Lordship, introvert, Lordship. She is shy in nature, and on the other hand, Lordship, this petitioner is handsome and, Lordship, his, Lordship, well-educated, Lordship.
How can you say that?
But, Lordship, things is that
no relevance.
mismatch of marriage, Lordship, but no cruelty, Lordship. I rely on the, Lordship, the 161 statement of Bijit Kumar Roy.
That's what I'm looking for. I'm not getting it. No.
Yeah.
Bijit Kumar Roy. It is like
Bijit K.R.
Have
Roy.
you marked it?
Yes.
Have you marked Vijit Kumar Roy?
My lord, some of the witnesses I have marked, my lord.
Sir, I have the copy, Lordship.
Hirendranath Burman? It must be here. I have not found it.
Yes.
Just give me 1 minute, huh? Complainant. Burman. Burman. What is the accused husband saying in the statement?
Husband says, Lordship,
Did
husband statement, Lordship, is there, Lordship. Partho Burman, Lordship. Previous night, Lordship, she has taken
Bijit.
only milk, Lordship, nothing else.
Separate. There is only
Then, Lordship, Mitchell Dotto, Lordship. Another witness, Lordship, Mitchell Dotto and Sonali Saha, Lordship.
will not go so much detail. Generally,
This is the bail application.
time
my lord,
constraint. No,
document
no,
to
not
prima facie, my
time.
lord.
We have some
My
time
lord.
constraint today. Try to finish everything.
My-
Anyway, so I
My-
just got them. Yes, tell me.
My submission is that, my lord, during the 15 months of the, my lord, marriage,
Mm.
she has
Mm.
committed suicide, my lord.
Mm.
And lordship may kindly page first page of the scan copy, my lord, there are screenshot. On the date of the, my lord, some screenshot was sent to the, my lord, message sent to his sister, my lord.
Mhm.
Lordship may kindly page what is here, my lord. How she is facing the torture from his husband, my lord. First part, my lord.
No, no, I saw the photos.
No, my lord, photo, no, my lord, screenshot, my lord.
Screenshot.
Tag mark, my lord.
I saw. I think I saw
Message,
that.
my lord.
I saw that only first page. No?
My lord.
Yes.
Oh, my lord.
Whether that was, Lordship, certified by their screenshot, Lordship. I said it's a matter of trial, Lordship.
Just now, this one.
My lord, that is.
This is in Bengali. She was a Bengali girl.
Bengal.
Specific date, he said.
I don't know. That is some
My lord.
daily life conflicts also it might
My
indicate
lord.
also.
And although my colleague has said that, my lord,
It might indicate some daily life conflicts also.
my lord,
Yes.
my lord, my lord. He
So we
also
cannot say
admitted,
really.
the accused also admitted that there's some physical, mental torture, my lord.
No,
From her.
No, my lord. From the accused also admitted that he has done some.
mental
Mental
is
torture,
also
my
is
lord.
the day-to-day life.
And although,
No, no, no.
although my,
Cannot be.
my lord,
No, that-
although my colleague said that, my lord, informed
That's
the
not
police, my
justified.
lord,
No.
but it was not informed, my lord. The
Proximity of time is not there, Lordship, because
person coming from the, after information, my lord, they have come to the, my lord, place and informed the police. Then the police, along with the police, my lord, they have come to the house of the victim, my lord.
then
Then it was
Lordship,
found that she was lying in the, my lord, room.
Lordship, the Lordship 160
Only
statement
this
of.
frame, my lord, my humble submission is that, my lord, at least some of the witnesses may be examined, my lord.
Lordship,
That
other, there is a
there-
bleak possibility, Lordship, there is a chance of conviction, Lordship. Already 110 days, Lordship, allow him to, Lordship, arrange his defense, Lordship.
2-7, my lord,
Hmm?
or evidence, my lord, 2-7.
2-7.
My lord.
The brother is the informant.
My lord,
Brother is the
my lord.
informant.
From the statement of the brother also. it is-
Chaudhary Land Council and B. Sharma invoking 483 BNSS. The petitioner is seeking regular bail in connection with Sessions case number 45 of 2026. Within bracket, Corpeta PS 19 of 26, under section 1031 of the VNS. Full stop. He was arrested on 7/3/2026 after lodging of the FIR and during investigation. The FIR was lodged by the brother of the deceased, with the allegation that his sister was married to the petitioner, who used to inflict mental torture upon her, and she used to relate that torture of the accused person. It is further alleged, it is stated that on 6/3/26, the accused called him and informed that his sister had committed suicide, whereupon he rushed there and saw her dead body. It is submitted that he suspects that the accused person had killed his sister and hanged her. Stop. The learned counsel for the petitioner, Mr. Chaudhary, has submitted that the case is poised for commencement of prosecution evidence upon framing of charge, and he may be granted bail to prepare his defense. Full stop. The statements of some witnesses recording during investigation has been pointed out, including one cousin sister stated to be a neighbor as well. The scan record has been received. The final opinion regarding that indicates asphyxia due to ante-mortem suicidal hanging. The learned additional PP submits that the case is fixed for prosecution. The case is fixed for commencement of prosecution evidence on 2/7/2026, and that the bail may not be bail can be taken up for consideration after examination of the initial crucial witnesses. I've given my anxious consideration to the entire matter. Full stop. In the circumstances, I find force in the contention of the prosecution. Accordingly, the bail petition stands rejected at this stage.
Lordship, instead of rejecting, Lordship, can it be fixed in the vacation court, Lordship? Can it be fixed, Lordship?
Then I have to change the dictation.
Because, Lordship,
Why?
because
can
Lordship,
file-
once rejected,
please-
Lordship, it may not be considered by the court.
File it again, because it will come before me, I'll remember also.
So can it be on, say, 2nd July? Lordship?
Don't necessary. This time.
The petitioner is custody for last 62 days. In the meantime, charge sheet filed. And opposite by informant party also appeared. And in this case, your lordship will find FIR is page 12. He's a plumber by profession, man. He also filed a case which is in point of time earlier than this case one. And you might have charge sheet file my, I think investigation complete matter, whether further custody, I am on that at this stage, man.
You file, what is your submission? Respond. Okay.
Also, is there one.
So you can submit, then you.
Here from the FI, it reveals that she was 14 years of old, my lord. As the charge sheet submitted, my lordship may call for scan copy, my lord. And after appraisal of the record, lordship may consider it there, my lord. Not at this stage, my lord.
And what is your submission?
Since CS is submitted, lordship, I leave it to your lordship.
You filed any objection?
No.
But she stated to be a mason. He stated to be a mason.
The plumber.
Plumber.
And informant son was my helper, my lord.
Whatever may be, my
And
lord.
once I
Not
fired
by-
him, my lord, this case was gone.
Not by profession, my lord, but only on the, my lord, offences.
No,
Yes,
your
for
lordship
the-
kindly see,
But he's 40 plus and he's only 15 years. He's a
14
minor.
years, my lord.
That's the,
my lord kindly see, my that, my,
so anyway.
For
So I
last
think
4 months, he has committed the offence.
we
my
can
lord.
keep
The
it pending and call for the scan
Fine.
record. That will be better. heard learned senior counsel.
Only one thing, madam, may I point out. Over the petitioner has filed idea and point of time.
Hmm.
He is a fire, madam.
Well, perhaps earlier it
No,
was
no,
called
no.
for scan copy.
Let me say, why you are intervening in that?
Earlier, he filed a
Yes,
FIR,
yes, madam. Your lordship kindly see page
32.
32. Vernacular is, madam, that will be better, madam, 37. Vernacular,
37.
37.
Okay, that is an important aspect. Anyway, let's see. He's been falsely implicated over.
Yes. Counter plus, madam. Yes. It was filed on 23, your lordship will find. And next page is of page 38. Your lordship will have bottom, my lord, 38. Received by GD entry number 23 for 26. Thereafter, this case was filed. And case is my lord, actually, in fact, they have assaulted me because I actually ousted their son because of some behavior, my lord. This is the reason why this case was lost, my lord. Anyway, my only question, my lord, since charge sheet filed, my lord, whether my lord, TCR will improve anything, my lord.
Because,
Rest I leave to your lordship, my lord.
it's okay.
Lordship, page 12,
I
my lord,
understand.
FIR, my lord.
Page
Yeah.
12.
Page 12, my lord.
That page 12
This
against.
FIR is subsequently filed.
My lord,
Yeah.
no, my lord, here, the
Yes.
accused person, namely Meher Ali, being a married person, has been committing forceful physical relation for last 4 months upon my minor daughter, so and so, in the absence of my family members. my lord.
For last 4 months, no information, nothing, no. Back statement, madam. And that was filed on 24/4, madam. That I just like to bring to your lordship notice, madam. 24/4/26.
This, what is the?
And mine
Should
is,
we
madam,
go for the case diary of this other
My
case?
lord,
Huh?
PCR, my lord, along with.
No, the
proceedings.
TCR and case diary of this
My
dispute PS case, because he claims,
My lord.
this is filed
that
on 23/4,
My lord.
dispute PS 269, and this is
madam,
the POCSO case.
another PS, madam.
Gorsuk PS.
Exactly.
Okay.
That may be also called for. my lord.
This is
This
dispute
will be in
PS
the
case.
TCR, this will be in the TCR, heard learned senior counsel. Who submits that
Control.
investigation.
What TCR already called, I have been told, madam.
Hmm?
TCR already called. TCR already called, madam.
Already called?
No?
Yes, yes, it's already called.
You already called.
Senior counsel submits that the investigation having been completed, perhaps the continued detention of the petitioner may not be necessary. First, drawing attention to FIR dated 23/4/2026, filed before dispute PS, filed before Odal Bakra OP under dispute PS by Mohar Ali, the accused petitioner,
Against informant.
against 4 persons, including the informant.
Yes.
Also, informant Malla Begum. It stated that they submitted that on 24/4/2026, the Malla Begum filed the incident FIR. Becomes very difficult to find out. You have to see the victim, the scan TCR has already been called for but not yet received. Full stop. Issue reminder for the scan TCR comprising case diary, charge sheet, including the statement of the girl recorded before JMFC, learned JMFC, if any. Full stop. Must have been recorded. Full stop. Also call for the case diary of dispute PS case number. This we should see. 269 of 2026.
269.
Dispute case number.
Scan copy to khali to number to mix up with our scan copy pertaining to Gorsuk case for 86 of 2026. To Gorsuk under so and so of the POCSO Act. Immediately after reopening. Immediately after reopening.
Obliged to lordship.
269 of 20.
Our name to be given.
Let's get it.
When do you propose?
Date, only date may be fixed, madam.
Yes. 16, 17, 17?
Mine.
16 or
17.
in custody, my person.
16, you want 16?
Mine.
Obliged to.
16.
My name may be recorded law.
Yes,
Inform.
16. Try to finish. Yes.
Lordship, I have checked the record, Lordship, this is awarded for that, case, Lordship, that promotion case, Lordship. Respondent number 2.
Just check it, please. You are appearing?
Oh, appear again.
Oh, he is appearing. Oh.
Oh, he have appeared.
Then it's okay. Is it
And,
Pokka case?
for lordship, TCR also call for lordship.
Not received. 4/2/26. Is it love affair?
No,
Love affair or in the context of love affair?
Oh, lordship. The high statement is there, lordship, 183 statement, lordship.
From the age I am saying,
Age lordship 16 years.
16 and 19. Anyway, but record will be necessary, I think, right? Let us wait for the record. Mr. Smoothie, Learned Counsel, and you are appearing for P. Botakur and your good name. The scan TCR as called for is not yet received. Full stop. Issue requisition reminder for the same. When should we fix it?
It's from Kamrup Metro.
Kamrup Metro.
15 to what? 19. I'm 19.
15/7.
Much obliged, your lord.
15, no?
15 lot. Much obliged, your lord.
35.
May it please your lordship.
Yes.
Under 483 daily application, my lord, the petitioner is 38 behind the bar, my lord, 38 days. The FIR each page, the relevant point of FIR each page 18, my lord. May I read that FIR, my lord?
I'll just go through it quickly. Alice cattle theft.
He is not involved in any cattle theft, my lord. It's that FIR reflect enter things, lordship. The cattle were recovered by 300 people as per the FIR. It's in the area of Apadanti state, my lord. And that cattle were disappeared from the spot between from the 300 people. And this petitioner is the owner of the vehicle only, my lord. And while he went to the police, Makum police station to filing his FIR regarding the theft of his vehicle, he was arrested. Under the presumption that he is the, my lord, involved in that racket. Otherwise, no, other main accused, my lord, he is still not in the custody, my lord. He is fled away. And my lord, kindly see the Annexure 3, page 24, my lord. This is the, my lord, seizure list. In the FIR, my lord, two vehicles involved. One is Alto, another is the petitioner's vehicle. The petitioner's vehicle is recovered, but the Alto is not recovered, not seized. And the most importantly, that vehicle is seized on 21/5/2025, 26, my lord.
This is one Maruti vehicle.
Maruti vehicle.
Burn condition.
Burn condition.
The cattle carrying vehicle was
It's a magic truck.
Magic truck.
And,
Anyway, so
and the entire story is, my lord, not tallied with the, my lord, the records, my lord.
anyway, so
He is the owner of the vehicle, my lord. My lord, taking advantage of the chaos, my lord, and
Can it be believable?
taking advantage of the chaos, the rescued cattle escaped from the spot and could not be secured thereafter. Cattle, my lord, escaped from the.
Now he is
And
38
my lord,
days behind the bar.
immediately after the incident, my lord, he went to the police station, the present petitioner, at about 11 PM, that to lodge an FIR that my vehicle was already, my lord, handed over to someone, my lord, and that day police arrested him.
yes, but
He is in jail from, my lord,
18/5.
can be allowed. Yes. Anyway. Lord Mr. Sons, Learned Counsel for the petitioner and P. Botak. 483 bail application seeking bail. Dumduma PS 73 of 26. Petitioner was arrested on 18/5/2026. The Azahar giving rise to the instant case was lost with the allegation of carrying of cattle in a Tata Magic vehicle. uh, uh, Along with suspicion of the cattle being carried for with the suspicion of the cattle being stolen and and that the cattle within bracket cows were also tied in a cruel manner with ropes. Full stop. The large number of people gathered and apprehended the vehicle. Full stop. It is submitted by the petitioner that the petitioner is the owner of the vehicle, Tata Magic vehicle.
Yes.
And he went to the police. He had gone to the police station on that day to lodge a complaint regarding theft of his said vehicle, but the police, suspecting him to be involved in the alleged theft of vehicle, theft of the cows, arrested him. And the petitioner was arrested on 18/5/2026. The case diary is received. Full stop. Progress of investigation?
Yes, investigation, my lord.
The investigation is reasonably progressed.
Yes.
In the circumstances, the petitioner is allowed to go on bail of 30,000 with one security, subject to the condition that cooperate with investigation, not hamper, cooperate with remaining investigation, not hamper or tamper with evidence, right?
Matter.
This was.
Page 54. 54.
हो जाओ 54. We filed an objection.
We have file available on record, Lordship.
It's commercial quantity.
Yes, madam.
47 kgs of methamphetamine.
Commercial quantity. The case is at the stage of trial.
Yes, Lordship.
No, trial has not started.
Oh, yes.
Lordship,
Yes.
trial is at the fake and only 2 witnesses are remaining. Cross part.
Oh, yes, sir. Right. Sorry. I have recorded also. 2 witnesses have.
And my lord, I am behind the bar 1,022 days.
Okay, sir. There's no difficulty in getting granting bail because of such length or in progress. But the only thing is that 37 application has to be seen. If it is found to be applied, then we have to wait for the trial to be completed.
Yes,
Expeditious.
Lordship, trial is in.
I will give a direction, but kindly see, make your submission.
May I please your lordship? My lord, in this case, my lord, at the very outset, I take your lordship, my lord. 36, kindly peruse 36.
Page 36. I don't think so. It's a short order, 36.
Okay, 36. It is, a record has come and I think 36, they have not complied with me.
It's a 36.
Dhananjay, that is better than. Yes. Ugla ki judgment records.
This is not connected to those issues, no, which we are taking up after some time. 36 is not.
36 is involved here, my lord. Kindly peruse, my lord, the trial court record has come. 36 and 48.
48 not complied.
Not complied.
Not complied. Then we can look at it. We could not get time. Okay, let's see it now. Wait, voluminous. We have to locate that notice. Notice is not there at all, or it is not sufficient.
It is not there. That's why not complied. They have not signed it, my lord.
Not there at all.
Not there.
48 is also not there. And my lord, regarding this, my lord, these two, 36 and 48, if they, even if 48 is not complied, but Bihan Kumar said that, para 26, that it is not substitute of 36. Para 26 of the judgment.
Yes.
Lordship, I have a prayer, Lordship.
Yes.
Lordship, similar matter has been listed tomorrow, Lordship. Same ground, Lordship.
No, all cases are taken up today.
Listed tomorrow, Lordship.
Today we are hearing this, whether violation of
36 and
notice
40.
not having signature will, no, because there are some different decisions. So I'm hearing a couple of them. Let us see if 48 notice is not there, then he will be entitled.
Yes. And
Let us see that.
Long delay of without trial, my lord, that is one. This is the trial was they are delaying the matter, my lord. 2 witnesses have been examined long ago, my lord.
Only 2 remain or 2 examine? 2 remain.
Only 2 witnesses are remaining, Lordship. Cross part remaining.
See, a cross part remain. They are not coming for cross also.
These are all depositions, madam.
They are also delaying the trial, Lordship. I have the order of the Lordship 26-5.
Let's get out of the blame game and complete it. Whatever trial should be completed on one hand. And bail, let us decide if it is. Can you have a quick look? Can you have a quick look? 48 notice. I have not noticed the 48 there. Can we see? Just check this. I will check this. Time constraint also to them. Let her go through then. Let her go through.
Yes, yes.
Then we will save time. Just go through, and if you find it, just mark, tag it. It next to the. 55.
Service report related molesting.
Pokto matter. Scan record has come actually.
Scan report come.
Kindly take instructions. Mr. Khanikar, and the scan report is available, but
Yes, my lord.
but steps have been taken.
Taken,
But those steps is stated.
Through APP matter have taken.
Stated to have been taken as per prescribed procedure, but service report is awaited. The prosecution is requested to take instructions regarding such service. When should we fix it?
17.
No other option.
Deployed.
6.
May I please, Your Honor? No, FI is at page number 11. 56, my lord, case diary not received. This is the third occasion, Your Honor. Case diary was called for, Your Honor.
You want me to see the FIR?
Yes, Your Honor. Page number 11, Your Honor. May I read, Your Honor?
Quickly,
Respected sir, madam, I hope this letter finds you well. I'm writing to bring to your immediate attention a great matter that has occurred in our locality, which demands urgent action, and from authorities, it has come to our light that a tribal girl from our community has been kidnapped. And it is utmost importance that the culprits involved in the heinous act be arrested without any further delay. I respectfully request that immediate steps be taken to ensure the swift arrest of the perpetrators and safe return of the girl to her family. This disturbing incident highlights a broader issue of growing concerns regarding the safety of tribal girls in our region. There has been alarming rise in incidents where tribal girls are being targeted and the community has been subjected to harmful practice of love jihad, which exploits and manipulates innocent tribal women. This issue has caused considerable anxiety and distress among the tribal communities. Therefore, I humbly request that the law enforcement agencies take the strict prompt action to prevent such incidents from happening in future. In addition, I urge that culprits be tried in fast track court under SC/ST Act to ensure that justice is served promptly and effectively. Your Honor, this is a case of love relationship, Your Honor. Your Honor, may Kindly see page number 15, Your Honor. There is 48 notice, Your Honor. Detailed grounds of arrest specific of the person arrested, Your Honor. In 48 notice, Your Honor, there is no mention of kidnapping, Your Honor. And Your Honor, if there is no kidnapping, Your Honor, SC/ST Act section
Girl has
2.
been recovered. Has the girl been
Yeah,
recovered?
recovered, Your Honor, recovered, Your Honor. She's 22 years old, Your Honor. It was a love relationship, Your
We
Honor.
need to see the case diary, sir.
Your Honor, this is the third occasion, Your Honor. Case
Please
diary
get the
happens.
case diary. If necessary, we can fix it in the vacation of court also.
Yes, Your Honor.
Which are the other two dates of vacation court? 32 that I have,
Yes.
and two more dates, sir.
Yes.
What are those dates? Are you aware?
Oh, those two are-
30 and 2 is mine. I don't know, maybe others also, but I have got duty.
13.
No, 13
So,
is opening.
2/7.
Anyway. So,
Immediately on the day of the opening. You know, it's for 63 days, you know, behind the bars, you know. You know, section, the SC/ST Act is not attracted, you know, in this case.
SC/ST Act, that is about insult.
Only on
Insult.
2/7.
SC/ST Act is about insulting.
Yes, sir.
Usual.
2/7 and 7/7. No? 7.
You know the dates?
7/7 only.
Kindly find out the dates, huh? Because we might need for fixing. 30 and 2 I know because I have been given. But the case diary is not yet received, full stop. The learned counsel submits that there is delay in receipt of the case diary, and that the ingredients of the SC/ST Act are not attracted prima facie, full stop. Issue reminder for the case diary, list on. I can give you one of the dates during the vacation course, but I know only 2 dates. Other 2 dates also should have helped to know. Ted told me, I forgot.
Any date during vacation.
You have to give a specific date.
2/7.
Second July.
2nd July.
But Mr. Sharma, please try to find out. Huh? 2nd July.
Map. What's it here, from a hotel, my lord, 0.671 kg, my lord.
Item number 57.
No, sorry. No. Bail application, item 57.
57. From a hotel, my lord, cooked beef was allegedly seized, my lord. Suspected to be beef, my lord. From a hotel, my lord.
Okay.
Page 11 is the affair, my lord.
Arrested on 11/6.
My lord.
Diary?
Diary
received, my lord.
That is the only allegation.
Yes, my lord. It is suspected to be, my lord, but it was sent for confirmation, my lord.
It is in violation of the
Section-
cattle.
Yes, my lord, section 8.
Because
Section 8.
4 and 5, my lord, without having.
non-permitted area. It is
Yes, ma'am.
or no, without license or something.
Yes, my
Without
lord.
license.
So my contention is that, my lord, whether it has been confirmed, only scientifically it can be confirmed, my lord. And it has been sent by the IO, my lord.
Scientifically, it can be confirmed for the purpose of criminal trial. But
Yes. Whether
people who are familiar can know, perhaps. Anyway,
This point, my lord,
we'll
statement
not
of-
go into this.
Statement of the witnesses is also available, my lord. They also.
No problem.
my lord, whether
I'll
other
allow.
custody.
Prisoner number 1 is the owner of the hotel and 2, my lord, cook, my lord.
No problem. Mr. Learned counsel for the petitioner and P. Potaku. Yogi Gopa PS case number 79 of 2026. The petitioners were arrested on 11/6/2026. They are the owners of the hotel.
Owner and cook of the.
The petitioners are stated to be the owner and cook respectively of the hotel where allegedly meat in the nature of beef was found in violation of the provisions of section 8 of the Assam Cattle Preservation Act. The case diary has been received. The prosecution submits that investigation has progressed and statements of witnesses have been recorded. The circumstances, the petitioners are allowed to go on bail of 30,000 each with the surety of the like amount reached to the satisfaction of concerned learned court. Yogi Gopa will be, I think, Vayapuri.
My lord, SDGM,
Oh,
not Salmara.
Huh? Not Salman.
Not
They
Salman,
are
Avayapuri.
to the satisfaction of the SDGM. And subject to the conditions that shall cooperate with remaining investigation, will not hamper or temporary evidence. They disposed of. Return case diary.
Obliged.
Okay. We go.
Timing item 36.
My lord. Office note says, my lord, service notice is awaited, my lord.
Awaited.
POCSO matter.
Okay.
Otherwise, my lord, petitioner is behind the bar for 34 days.
CD also not here, madam.
We
Then
have
on
to wait.
17 July, my lord, it may be taken up.
Mr. Ali, learned counsel for the case diary is not received. Service report is also awaited upon respond number 2. The prosecution may take instructions regarding service.
Well,
Full stop. List on 17/7.
Obliged.
17/7. 6.
Yes, Harry, proceed.
One second. Evening.
May I please, your lordship. The offense is under section, my lord, 9 of the POSCO Act, my lord. No, actually, my lord, the victim is my wife, my lord.
Acha. 9 of the POCSO.
Yes.
Child marriage is there.
Child marriage also there.
PCM, my lord.
And,
Child marriage and section 6 is POCSO.
Oh, sorry, ma'am.
You are for the informant, sir.
My lord, actually, my lord, the
My date of birth has been wrongly recorded in the Aadhaar card. The basis of that also the FIR has been lost.
You claim to be a major? You claim to be a major?
Major.
Well, in the last order, lordship was to pass interim order on the basis that there is a possibility of lordship may kindly for last order.
I'm not past another court. Anyway, no problem. I've seen this.
Last order.
Mhm. It's a AB. So
AB, ma'am.
Charge-sheeted case.
okay, then can be confirmed.
Next day is fixed on minor 2/7/26 for appearance, my lord.
For appearance. I have received the notice, ma'am.
He did heart and land counsel for the informant also. I do 4-5 or 2 low by 4-5-26 or low by system. The land counsel for the informant submits that the case the petitioner was prosecuted on the basis of her age indicated in the Aadhaar card. It was wrong.
It was wrong, lordship.
And further containing that the age recorded therein suffers from error, and that at the time of the alleged incident / marriage, she had actually attained majority. What do you say?
Date of birth is 5/2/2007.
It is submitted that her actual date of birth is 5/2/2007. Full stop. In any case, investigation is completed. And,
Already interim order is there.
oh, interim order is there.
Yes, ma'am.
Lordship may
Oh, I
kindly-
see.
in the-
Petitioner was granted, why it is? The interim, the petitioner was granted interim bail on 4/5/2026. In the circumstances, I do not deem it necessary to make any change in the interim order to the prejudice to the change in the interim order, full stop. Accordingly, the same is make any cancellation of the interim order. Accordingly, the interim order is hereby made absolute, subject to the condition that the petitioner shall cooperate with the process of law. Allowed and disposed of.
Highly obliged, ma'am.
The ABS.
My lord, petitioner is on interim, my lord. CD probably is not.
My lord.
Mr. S. Das, the petitioner was granted interim bail on 7/5/26. Case diary is not received. Issue reminder interim vice stands extended till next date of listing.
23rd, my lord.
Highly obliged.
Yes, Mr. Khan.
May I please, your lordship? Page 12 is the FIR, your lordship. Herein only allegation is that, your lordship, a complaint was received from the public. Page 12. A complaint of page 12, your lordship.
Page 12.
12.
Yes.
Herein the allegation is that, your lordship, a complaint was received from the public regarding cow slaughtering, your lordship. And consequently, there was an operation, and the operation was done at the house of one Ilyas Ali, your lordship. And from his possession, some beef was recovered, and subsequently that man was arrested. And he reveals the name of the present petitioner, your lordship.
Okay.
Only this is the allegation, your lordship. And based upon that, your lordship, a case under section 13 subsection 1 of Assam Cattle Preservation Act has been registered, read with section 11 subsection 1 of Prevention of Cruelty to Animal Act 1960, your lordship.
No.
But the
Yes.
But the fact is that, your lordship, it is admitted fact the petitioner purchased beef, your lordship, from that person who was arrested and from whom the beef was recovered, your lordship. And the area, your lordship, the area is also not within the restricted area as provided in the law. It is a Muslim dominated area, your lordship, and I have mentioned in para 6 of my petition, your lordship. So I'm humbly praying, your lordship, he is ready to cooperate, your lordship, and who may be allowed.
My lord, in the last occasion, lordship was pleased to call for a report from the IO, my lord. Lordship, kindly play last order, my lord.
Yes.
Regarding the restricted area, whether it is restricted area or not.
Oh,
And regarding the FSL.
no, only that will determine whether it is violative of these things. But CD is received.
CD received, my lord.
It's not indicated there.
My lord, not, my lord, here I have received the report also, my lord, from the IO, my lord. Here, lordship may kindly play with the report, and FSL report received is a gift, my lord. It has confirmed gift, and from the statement of the witnesses, my lord, along with the arrested accused, my lord, it was said that for a long time, my lord, the present petitioner has doing the illegal slaughtering of the, my lord, cow, my lord. And only the arrested person, he said that he has helped.
Yes, help.
In this process, my lord, but main person is the, my lord, present petitioner.
Yes.
My lord, but may kindly play with, my lord, your statement and report, my lord.
And is it in the restricted area?
My lord.
It is in the restricted.
Within the restricted area.
So 8 may be violated.
My
per
lord,
se.
8 will come, my lord.
What to do then?
And thereafter, my lord, witnesses, my lord.
Anticipatory bail maybe.
My lord.
Herein, your lordship, the petitioner, your lordship, he met a fatal accident, your lordship. And as a result of that, he got fracture injury, your lordship. Page 15.
Near fatal.
Page 15, your lordship, I have annexed a copy. Page 15, your lordship. Page 13 one or your lordship. So,
That
your
can
lordship,
be, that can be a factor. Also. Anyways,
so I am humbly praying, your lordship, any condition, your lordship, he may be, your lordship.
A.M. Khan, Land Counsel for the petitioner, and Sharma, that additional PP. The petitioner is seeking pre-arrest bail under 482 BNFS in connection with Jogi Gauhati PS case number 58 of 2026 under so and so section. It is alleged in the Azahar dated 7/5/2026 lodged by SIM Medhi of Jogi Gauhati PS that the house of one Ilyas Ahmed was searched upon information and suspected meat and meat suspected to be beef was seized from the possession, and subsequently he revealed that one Rashid Ali, within bracket petitioner, and Fazur Ali of Sidamari were involved in the said activities. The learned counsel for the petitioner submits inter alia that in April 2026, the petitioner met with an accident resulting in multiple fractures, and in support of the same, he has submitted annexed some medical documents. You peruse the same. The medical report, medical prescription dated 18/4/26 indicates injuries due to an accident, and the radiological report also indicates fracture, full stop. On the other hand, the learned additional PP submits that the petitioner, there are incriminating materials against the petitioner about violating the provisions of the Cattle Act,
Section 8 of.
especially Section 8, and that a report of the IO, which was called for, also indicates that it was such activities were being carried out in areas where these are not permitted first. However, I've seen the progress of investigation. Though there are adverse materials implicating the petition, but considering the progress of investigation and also the aspect of his injuries sustained in an accident, I deem it fit to allow this bail petition. Accordingly, it is directed that 50,000 with 1/0 conditions above. He shall cooperate with remaining investigation, shall not hamper or temper, shall not indulge in any activities violative of Assam Cattle Preservation Act, especially Section 8. Violation will entail cancellation of the bail. Return case there.
All right.
43. My lord, here we have received a case diary, my lord. Service report awaited, my lord. We are trying to contact my lord, but today not received, my lord.
The case diary has been received. However, service report upon respond number 2 is awaited. The prosecution shall take instructions regarding the same. List on 30,
My lord.
36, 30th June.
Can it be on?
Yes.
30.
Any,
Okay, 32. God bless. 42.
May I please, Lordship? Hello, this is a POCSO case, Lordship. Notice has already been issued. My lord, amicus curiae has already appeared, Lordship. My lord, FIR, Lordship, your Lordship will find out.
Objection file করবে।
What objection? File কিয় কৰিব লাগে?
কিয় নালাগে?
We need some time for filing of objection.
your good name, please, madam. Your good name, please.
R. Shaha Lordship.
Sir.
File or wakalat.
You're not amicus, privately engaged. Huh? The case diary is received.
My
Case
lord.
diary is-
The case diary has been received full stop. However, Ms. R. Saha, learned counsel, has entered appearance on behalf of the informant and seeks to file an objection. How much time would you need to file an objection? After vacation?
30 or 50 years.
Is the matter, what did you retain the case
My
diary?
lord, it is after vacation, we will have to return back.
No.
Why?
Last time, my lord, this CD has.
What are the, could you find out what are the other two dates? The
My lord,
vacation.
my lord, not yet confirmed, my lord. Sometimes I have heard that the
Registry will-
7, 9,
Registry will
7
be-
and 9, but not any notification is yet to come out.
Registry, okay. Yes. So I leave it to you. I can fix it one of those days in between or on reopening.
Fine.
Or on reopening. Retain the case then
My lord,
Yes.
on 13th.
13, my lord.
Obliged.
13.
Case diary be retained.
Well.
Otherwise you will get late.
May it please your lordship. So it's an anticipatory bail application. Case diary has perhaps come, madam. Item 45. So this is a case under sections 303 subsection 2 and 317 subsection 2, my lord.
Better.
Theft and, my lord, dishonest receipt of stolen property, my lord. Here, my lord, in this case, police team found around 300 batteries, my lord, loaded in a truck, and then an additional amount of 525 number of batteries in the residence of the petitioner, my lord. So the
Large number.
police suspected that these are stolen batteries, my lord. Now, if your lordship will kindly see, first page 20, my lord.
Large number of batteries.
No, yes, my lord, and we have the explanation for everything, my lord.
825 numbers of batteries, my lord.
Yes,
Anyway,
we have the explanation for everything. Page 20, my lord.
20. Police alleged that they were stolen.
Stolen, my lord. They suspected that this was stolen.
Suspected to be stolen. 20.
Page 20, my lord, this is the GST registration of this proprietorship, my lord, MS Robinson Cycle Store, my lord. The petitioner happens to be the proprietor thereof. And the petitioner, my lord, he deals with, my lord, the batteries, my lord. The lordship knows that batteries, my lord, they get refurbished, my lord. Whenever person buys a new battery, my lord, the old batteries are given back and they are refurbished and they are again sold back. So this petitioner, my lord, he deals in these refurbished batteries. So he purchases it from different places and, my lord, he sends it to UP, my lord, where these are again, my lord, refurbished and sent back. Now, if your lordship will kindly come to page 24.
Okay.
24, this is a receipt for, my lord, purchase of 66 number of batteries, my lord. Then at, my lord, page 26, 67 number of batteries, my lord.
Yeah.
Then page 28, my lord, here the number of batteries is not mentioned, but it's another receipt for purchase of scrap battery, my lord. Page 30, my lord, there's again another receipt, my lord. Page 32, here he has purchased 350 number of batteries, my lord. All in the name of the proprietorship of the petitioner, my lord. Page 32, your lordship will see 350, my lord.
KG.
No, 350 is the quantity, my lord, number of batteries, my lord. Yes. Then at, my lord, page 34
Yes.
is another receipt, my lord. Page 36,
2000 batteries.
my lord. No, 2000 is the weight of the battery. Weight, amount is not, quantity is not given. 24, my lord, 24 number of batteries. Then at page 38, my lord. Again at, my lord, page 40.
Right.
Page 42. Then, my lord, page 44. And finally, my lord, page 46 and 48, my lord. My lord, there's another one, my lord, at page 50. So, my lord, we have been purchasing these batteries validly. These are purchased in the name of our proprietorship. The fact that the proprietorship is in the name of the petitioner, my lord, that is apparent from the registration certificate of the GST, my lord, authorities. So the police suspected at that point of time the petitioner was not there. So these documents could not be furnished to the police, my lord. So this is a case, my lord, where the punishment is less than 7 years. So this is a case ideally where the police ought to have issued a 35(3) notice. We would have appeared with all of these documents and, my lord, the police could have verified if these are genuine or not. But the 35(3) notice was never issued, my lord. And in fact, one more thing, my lord, the vehicle in which this 300 numbers of battery was found, my lord, that vehicle, my lord, we filed for that vehicle has already been given in Zimma, my lord. That order, my lord, I have.
A 35(3) notice would have clarified everything, man.
Yes, Mr. Sharma.
Well, here we have received the case there, my lord. Here 825 numbers of batteries were seized from the my lord possession of the my lord present petitioner, my lord. At that time, they have failed to produce any documents, my lord. And from the witnesses, my lord, and some of the witnesses and labor, my lord, it was said that as per instruction of the my lord Azharuddin, it was loaded in the truck, my lord. And at that time, they have failed to produce any documents. And here, that much is here, my lord. CD, my lord, let him appear and produce the my lord documents for verification, my lord.
My lord, that can be done.
Otherwise, my lord, they have said that these are documents they have, my lord, but in the city that part is not available. My
This is an admitted position, my lord. We have not denied that we have loaded those.
No. But as now as learned counsel for the petitioner, V. Sharma. The petitioner is apprehending arrest in connection with Howley PS case number 82 of 2026 under so and so section, and has filed the instant petition under 482 BNSS. Full stop. An FIR was lodged on 6/6/2026 by the
SIF police.
by a police official of Howley PS. The gist of the allegations was that one truck bearing registration number UP 38804717 was parked in front of his house, and it had large number of batteries, and subsequently during search another 525 batteries, 300 batteries were found earlier. 525 batteries were of different brands were found. It is alleged that the said 825 batteries were without documents and suspected to be of illegal origin. Mr. Nawaz learned counsel submits that a petitioner undertakes a business of buying old batteries upon selling of new batteries, and after refurbishing of the said batteries, these are sold to other parties. Full stop. And the batteries in question were in the process of being sold to one party in UP. Full stop.
No, it was not being sold for you. It was being sent to UP
For
refurbishment, my lord.
The batteries were being sent to one party in UP for such refurbishing. Full stop. Several numbers of such receipts pertaining to the purchase of old batteries have been annexed and have gone through the same. It is submitted that the case being punishable under 7 years, the police could have issued a notice, ought to have issued a notice under 35 ENSS, whereupon these documents could have been placed. It is submitted that placing the relevant order in this regard, it is submitted that the vehicle has been given in Jima. The vehicle has already been given in Jima to the owner. The case diary has been received. The learned additional PP submits that at that time, and in absence of documents, the origin of the said materials were considered to be doubtful. Full stop. The prosecution submits that perhaps the petitioner can appear before the IO and submit his documents. Upon considering the matter, is directed that in the event of his arrest in connection with this case, allowed to go on bail of rupees 50,000 once security of the light amount to the satisfaction of concerned arresting authority, and subject to the conditions that he shall cooperate with remaining investigation, appear before the IO for examination along with documents. He shall not hamper or tamper with this. Return case there.
That's a disposal or increase?
Disposed.
Disposal.
Since there is come disposed.
46.
May I please, your lordship. The matter pertains to the POCSO matter, lordship. TCR along with the case diary was called and instruction was there to issue notice, lordship.
My lord, here service completed, my lord. We have received the, my lord, service report, my lord, today.
If service is complete, scan TCD, scan
CD
TCR.
receipt, CD receipt.
Huh?
CD receipt.
CD is received also.
Amicus.
Amicus has to be appointed. Appoint amicus. Very good. The case diary has been received, however, and it is also informed by the prosecution that service upon private respondent is complete.
Oh, nine, amata bhai.
We have the same M.R. Brown, M.K. Brown, learned counsel for the petitioner. Learned counsel is appointed as amicus curiae to represent the informant. The learned amicus may be given a copy tomorrow.
Reopening, lordship.
Okay, that'll do.
13, lordship.
You furnish her a copy.
And lordship, her name may be reflected on the cost.
Yes. The name of the amicus may also be reflected in the cost list.
Deeply obliged.
CD written, my lord.
CD be written.
Oh, you want to, oh, yeah, that's, will it hamper
Perhaps, my lord, not, my lord.
on 13?
Supplementary 58.
Deeply obliged.
Last one, or bail as any? Bail 9. Sure, no? Bail 9. Yes.
My lord, service not completed, my lord. Here,
POCSO.
my lord, POCSO is not. TCR also called for, my lord. Also not received, my lord.
It's evidence is going on. Trial is going on.
Actually, my lord, trial not yet started, my lord. We have received summons, my lord. It is in the stage of appearance, my lord. Only thing is, my lord, charge sheet has been filed and the petitioner was shown as absconder, my lord. And the petitioner accused number 1.
That is why you are apprehending.
Yes, my lord. I am otherwise, my lord, willing to appear, my lord, and take
My
the
lord,
trial.
here, notice it was required, my lord.
This scan TCR is has been received.
Not this.
Not received.
What service?
The scan TCR has called for not received. Issue reminder for the same.
My lord, regarding service,
Steps have been taken, but no, the office not served.
my lord. Not service.
Notice has been sent, but like X. The prosecution shall take instructions regarding service upon the respond number 2.
Date may be
On
a reminder for.
yeah, issue reminder for TCR. We have written already.
22nd, man.
Okay.
20.
20.
Yes.
Obliged.
Very forward. Man, order to Pelego আছে. লৈ লোৱা ভাল নেকি এইটো না অৰ্ডাৰ্ছ আৰু আছে তো এডমিশ্যন আছে তো বেলটো লৈ লওঁ তাৰপিছত লৈ লওঁ বেল ষ্টাৰ্ট কৰি লওঁ হেৰি হ'ব connected bills we can start.
23, 25, 24, 25, 28, 52, 53, 41.
Item এটা ক'বচোন নাম্বাৰ item number এটা 23, 24 আৰু 25 52. এক দুই তিন চাৰি পাঁচ ছয় সাত সাতটা we have already gone into the issue. Now it needs to be concluded.
My learned friend response to my submissions from the last day, my lord. Sum and substance was that, my lord, these are two standalone provisions, my lord. Do not overlap, and one is not a substitute of another. Just one judgment, my lord, one paragraph, Supreme Court judgment, my lord, which recognizes that these two are, my lord, standalone provisions, my lord. Ashish Kapoor. Itu apnar criminal appeal 1518 of 2025. If your lordship will kindly.
Yeah, I've seen this judgment somehow.
Herein, my lord, the issue was
Ashish Kapoor.
yes, my lord, that it was a proposition was made that an arrest, if the grounds of arrest are there in the arrest memo, my lord, it suffices the written communication of the notice, my lord. But the Honorable Supreme Court recognizes that these are two different provisions, my lord. Your lordship will kindly see the second page, last paragraph, my lord. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the arrest memo cannot be construed as grounds of arrest, as no other worthwhile particulars have been furnished to him. So this contention here remains the same, at least, my lord, though it has not delved in detail, my lord, but the very fact that these are two arrest memo and the notice happen to be two different standalone provisions, my lord, this finds recognition here, my lord. Rest, my lord, my learned friend, Mr.
This was held to be not a substitute in the context of inadequate particulars or generally also. I have used this judgment or this decision in one order, I think.
Yes, because
last year.
This is in general, because here in the arrest memo, it was mentioned specifically that the arrest had been made based upon the statement of the co-accused. So ground was there in the arrest memo. But the Honorable Supreme Court says that no, this is a standalone arrest memo, a separate ground of arrest where the particulars individually had to be given. That was missing here. Rest, my lord, subject to what my learned friend says.
Now, my lord, on that day also, my lord, now today, my lord, he has submitted this Ashish Kapoor judgment, citing that both provisions are standalone, my lord, provisions. So, my lord, both has to be complied with, my lord. Now, my lord, my argument that at present, the present position is that, my lord, with me, my lord, that there are conflicting views of the coordinate benches of our Honorable High Court. With me, the present position is there. There are, my lord, I have also some of the, on that day, my lord, he has submitted a detailed list, my lord. Some of the, my lord, goes in against them and some in favor of them, my lord. And my lord, regarding that aspect, my lord, I would like to point out, my lord, suppose, my lord, already, my lord, admitted position that there are all those judgments already, my lord, submitted before your lordship list. Now, suppose your lordship, my lord, disagrees, my lord, with or agrees with one of the view of the coordinate bench of our Honorable High Court. Suppose today, my lord, your lordship may allow the, my lord, bail petition or rejecting the bail petition. Your lordship has your lordship's own reasonings, my lord, on that. Now, my lord, suppose your lordship reject the bail petition, and my lord, then also, my lord, one new controversy will allow, my lord. And what the trial court, my lord, and other courts, what or which order will followed by the trial courts, my lord, in case of, my lord, NDPS for granting bail and in following the, my lord, orders passed by this honorable court, my lord. And so that controversies, my lord, still remain, my lord, in view of the various, although, my lord, with due respect to all the judgments of the, my lord, coordinate benches of this honorable court, my lord, so my first submission before your lordship, because of this admitted position, my lord, regarding standalone provision, as my learned friend has pointed out, this Ashish Kapoor judgment, my lord, that judgment till now I have not gone through, and earlier they have not produced that judgment before any of the, my lord, coordinate benches of the Honorable High Court. And if, my lord, they have produced, my lord, coordinate benches, then, my lord, how, my lord, regarding then, my lord, then even after placing their judgment, some of the, my lord, coordinate benches of our Honorable High Court differed and my lord, accordingly, my lord, bail petition, my lord, rejected, my lord. Considering that, my lord, here your lordship has on that day rightly pointed out regarding Subhash Sharma's, my lord, judgment. I would like to point out, I am not on your lordship, one line of the
Subhash Sharma.
Subhash Sharma versus, my lord, Directorate of Enforcement versus Subhash Sharma. my lord. That is, my lord, paragraph 7. I am just reading, my lord. Once a court, while dealing with a bail petition, bail applications, finds that fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, while arresting the accused or after arresting him. It is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is the duty of every court to uphold the fundamental rights granted under Article 21, 22 of the Constitution. So, my lord, that is, my lord, in case of violation of the fundamental, there is no doubt that in case of violation of the fundamental right of the accused under Article 21 of the code, the accused is entitled to bail. Our argument is that, my lord, in view of, my lord, source of the, my lord, provision of the section 36 is the Constitution. Source is what, my lord, DK Basu. And my lord, 47, 48 is also source is the Constitution. That is in view of Bihan Kumar violation of the fundamental right in both 36, 47, 48, my lord, and thereafter, my lord, and my lord, logic is, your lordship may kindly see. So within 24 hours, my lord, police has to comply all the provisions of 36, 30, 47, 48, and ultimately, my lord, has to produce by following the Subhash Sharma's judgment within 24 hours.
That is the
So
challenge.
police has to complete everything within 24 hours. And in case of any violation, my lord, that goes in favor of the, my lord, accused, and accused is entitled to bail. So I am not going to dispute about fundamental right of the, my lord, accused person, a fundamental right of this accused person. And here, your lordship, there are lots of judgment. One aspect also is that I would again like to point out, although not differentiated, but all these cases are NDPS cases, huge quantity of contraband. And my lord, 37 of the
Very serious case.
NDPS is also there, and that is also in view of the provision of the constitution that 37 inserted. And my lord, till now, no one has said that the provision of 37 of the, my lord, NDPS is, my lord, ultra virus of the Constitution. Still holds the.
Once upon a time, it was challenged. I think it was upheld.
Yes, upheld, my lord. And now in all these cases, my lord, which the judgments of the honorable, my lord, coordinate benches of our honorable High Court, my lord, your lordship, I would like to point out one of our argument is that, my lord, although, my lord, section 48, 47 complied with, only it's regarding section 36, my lord, memorandum of arrest, my lord, signature of the attesting witness is there. By that, while, my lord, section 48, my lord, complied with, 47 complied with, 36 also, my lord, it cannot be said that, my lord, total non-compliance. 36 also complied with, but only the signature of the attesting witness is there, my lord. Thereby, while, my lord, 48 already complied with, there is no violation of the fundamental right of the, my lord, accused persons, and thereby, while, my lord, 48 already fully complied with, 47 complied with, and in fact, my lord, 36 also, my lord, partially, my lord, substantially complied with, my lord. Then, my lord, the accused cannot, my lord, say that my fundamental right violated, and it cannot be, my lord, on that day, my lord, although, my lord, I have not gone through my lord, procedural law is not for the ends of justice, not for frustrating the justice, my lord. And, my lord, it cannot be, my argument is that although, my lord, that both, it cannot be directly said that all provisions of the, my lord, 36, 48, 40B, there is no relation between all these provisions. Once again, I would like to, my lord, read exactly, my lord, again, my lord, for I would like to again read, my lord, section 36, my lord. Because, my lord, procedure of arrest and duties of officers making arrest. So source of that 36 and objective behind, my lord, inserting section 36 is the, my lord, DK Basu, and thereafter DK Basu, on the basis of that DK Basu, ultimately, my lord, legislature had made this statutory law and provide, my lord, this section 36 inserted, my lord. And every police officer, while making an arrest, This is the item, my lord, heading procedure of arrest and duties of officer making arrest, my lord. Every police officer while making an arrest shall bear an accurate, visible and clear identification of his name, which will facilitate easy identification, that is government. B, prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person attested, who is member of the
Arrested.
family of the person attested, or a respectable member of the locality where the arrest is made. Here there are two, my lord, one is, my lord, family and one is respective member of the locality. Countersigned by the person attested. That's one next important, my lord, provision is 36C, my lord. Inform the person arrested, comma, my lord.
Yes.
Inform the person arrested, that is the accused, unless the memorandum is attested by a member of his family. Here, my lord, locality, my lord, member of the locality, that is not there, my lord. Unless the memorandum is attested by a member of his family, then he has a right to have a relative or a friend or any other person named by him to be informed his arrest. So at this point of time, he has to, my lord, first inform the person arrested, unless if, my lord, memorandum is already attested by any relative or, my lord, family member, that question will not arise. Then, my lord, your lordship may kindly come to section 48, my lord. 48. My lord. All right. Obligation, my lord. Obligation of a person making arrest, because a individual person can also, my lord, arrest to inform about. Obligation of person arrest to inform about arrest, etc. relative or friend, my lord. How it can be said that, my lord, there is no correlation between, my lord, section 36 and 48, that I want to point out before your lordship. Every police officer or other person making any arrest, because any individual also can arrest, my lord, under this Sanhita, shall forthwith give the information regarding such arrest and place where the person is being held to any of his relative, friends, or such other persons as may be disclosed or nominated, my lord, here no, by the person for the purpose of giving such information, and also to the designated police officer in the district. The police officer shall inform the arrested person of his right under subsection so and so. So, my lord, here section immediately after section 36, my lord, 48, my lord, where is the, and one thing is clear, that everything has to be done by the police within 24 hours. At the time of arrest, my lord, memorandum of arrest, and sources of every, my lord, provision is constitution. My lord. Immediately after 36C, my lord, 48 specifically stated about informing the family members or, my lord, any relative. Suppose, my lord, for a moment, my lord, logically, my lord, police suppose fail to, my lord, suppose, my lord, the procedure memorandum or attesting witness is there, my lord, not arrested, but everything there was date, time, everything was, my lord, entered in the memorandum of arrest. Now, my lord, immediately thereafter is section 48 notice served. Well, whether that purpose could be, my lord, not served, my lord, how can that, my lord, while fundamental, the 48 is also, my lord, source is the, my lord, constitution, my lord, article 21 of the constitution. Immediately thereafter, my lord, this 48 notice served, purpose, whether can it be not said that purpose is served, my lord? So, by considering that aspect, my lord, 36C and 48, my lord, this, my lord, coordinate bench over Honorable High Court, my lord, I would like to point out. That is, I'm reading, my lord. That is, my lord, BA number 887 of 2026. paragraph 12. The purpose of the arrest memo
You'll be
under
submitting,
section,
you'll be submitting,
I'm just reading, my lord.
you'll submit the judgment order.
That is there, my lord, in the
Already there
compilation.
in
The
the
compile-
compilation, my lord.
Page 132.
Page 130. That is, my lord, bail application 887/26, Jabbar Hussain. Paragraph 12, my lord. The purpose of the arrest memo under section 36 BNSS is that it is the formal record of deprivation of the liberty of the arrestee, and its primary purpose is to provide legal accountability for the arrest itself. Therefore, preparation of the memorandum of arrest mentioning the date, time, place of arrest, as well as the place where the petitioner is being detained are all are mandatory requirements of law. The necessity of taking signatures of witness of the kind mentioned in section 36 on the arrest memo is obviously an act of attestation of the particulars mentioned in the memo of arrest. That being the position of law, if the said particulars as available in the arrest memo with regard to date, time, and place of arrest, etc., are communicated to the family member, friends, nominated person by way of a notice under section 48, the same purpose is served. Now, on that day, my lord, one of my friend, my lord, argument has been made that he argued at the last point of time that suppose, my lord, in the memorandum of arrest, my lord, there is no attesting witness. Suppose at later point of time, my lord, some dispute arises regarding date, time, arrest of the person. Suppose, my lord, accused person was illegally detained. All these things is submitted, my lord. In that case, my lord, suppose any, my lord, whether all these petitioners, my lord, in all these cases which are pending before this honorable court, at any point of time, whether any dispute raised because of the, my lord, at that point of time, there is any dispute regarding other contents of the memorandum of arrest, that police has illegally detained them, police has, my lord, caused anything, police has done any harm to them, my lord, and whether there is any discrepancy in the recording time and date and arrest in the arrest memo, my lord, whether those disputes, my lord, in all these cases at any point of time raised by these accused persons, my lord, whether they disputed other contents of the memorandum of arrest before any authority will earlier point of time, because they agreed, well, there is no violation, police has not caused any harm, police has not, my lord, done any illegality by, my lord, while, my lord, preparing the memorandum of arrest, other contents, everything is legal, but not attesting witness is there, and the purpose of which served by section serving notice under section 48, that is my argument, my lord. And that is also supported by the coordinate bench of our honorable high court in this paragraph, my lord. And regarding other decision of our, my lord, coordinate benches on one of the Calcutta division bench of the Calcutta High Court is also there, my lord. I will point out, I will not read all those judgments, my lord.
What was it, what was the decision, Calcutta High Court? Cannot be very.
Compilation submitted by my learned friend, my lord.
Hero Sarkar.
Yes.
Hero Sarkar has been otherwise, my lord, dealt with.
What did it say?
That
you will apply. Paragraph 17 and 8, my lord. 17 and 18, my lord.
37 will not prevail over
Yes.
36.
No, that Hero Sarkar says that 37 will prevail
Over 36.
36. But our honorable high court has already distinguished that aspect. Supreme Court has also analyzed that aspect, my lord.
No, 30, as far as 36 is concerned, your entitlement to bail due to non-compliance with 36 hinges on this question. That, say, with regard to 47 and 48, this has been settled because this is new law. And it emanated from DK Basu, incorporated in CRPC, then in BNS, of course. Now, the question is that whether that particular procedural irregularity or non-compliance is a mere procedural irregularity, or that procedural irregularity amounts to violation of fundamental rights. That is the issue. If it amounts to violation of fundamental rights in the context of the present legal position,
because, my lord, my
arrest becomes
argument
illegal.
is that this is simply this is a procedural irregularity, my lord, and my lord, this is not violation of fundamental. While, my lord, 48 is already 47 complied with, although my lord 36 is, it is not their argument that 36 is not totally my lord complied with, my lord. That 36 the substantially complied with, but not only the my lord, my lord witnesses of the attesting witness is not there. So my argument is that the my lord arresting authority has not violated the fundamental right of the accused, although my lord that procedurally my lord illegality or irregularity is there, my lord. While my lord complying the provisions of section, that procedurality irregularity my lord also my lord made by the arresting authority, and my lord as such the my lord fundamental right of the my lord petitioner were not violated, my lord.
Okay, that is your submission.
And my lord, and regarding my lord, while I would like to, for my lord, although on some different aspect, I would like to point out one of the judgments of our coordinate bench, while in that regarding dispute regarding my lord production of the accused within 24 hours was raised, my lord, and that point was never challenged for many years, my lord, at last before any of the trial courts, my lord. And later on, my lord, that point was raised before this honorable High Court after a long lapse of time. Our coordinate bench of our High Court, by citing the decisions of the Subhash Sharma and Niranjan Prabhakar, my lord, Niranjan Singh versus another, the coordinate bench, my lord.
Which one?
That is not, my lord, there in the compilation, my lord.
You can give me.
I will provide to the my lord.
The judgments which you are giving.
Only I am pointing out.
The judgments which you are giving exclusively from your side.
Yes.
Just compile them.
Because I am not providing any, because already those compilations.
Anything else if you're giving.
Only I will again provide those judgments which supports my lord us now.
The other question is that in matters of compliance with fundamental rights, especially fundamental rights pertaining to liberty, whether substantial compliance would suffice or whether like strict liability, strict compliance has to be insisted. That is the second question. The third question is that whether, as that was the initial argument, initial point, whether 36, 48, 47, 48, of course, we always have to read as a whole. Now, this is a continuous, see, this is a continuous, spectrum of, whatever you call it, of judgments from Arnesh Kumar until it's a journey. Actually started for DK Basu, even there Joginder Singh arrest, then
every judgment is
then Mihir Rajesha, and then Darshan takes a different view.
Yes,
it could be indicative of a new further development of the law.
Darshan Kumar
Right.
also, my lord,
So
at
that-
some point of time
so-
supports us, my lord.
Okay, so that is indicate. So that seems to indicate substantial compliance. The question, the other question, as I said, which arose at the outset, is that these have to be seen together all the time. But whether, as far as compliance is concerned, whether they have to have standalone compliance, standalone strict compliance, each of them, or whether you see the compliance across these three sections, and if broadly it has been complied, then it can be taken to be taken to have not violated fundamental rights. We also, I think, come at that question.
My argument is before your lordship, by substantially complied with by this section, complied with section 36, and my lord, otherwise, my lord, there is strict compliance of 47, 48 is already there, and my lord, thereby, my
No,
lord.
Darshan does not say strict compliance.
Yes, my lord.
We are following
Substantial
Vihan
compliance,
because
yes.
of the earlier point
Yes,
of view,
yes.
Pranay Sethi and all that.
If we go in, my lord,
Anglingam
hyper-technicalities, otherwise there are if you go, my lord, all these hyper-technicalities, my lord, ultimately, my lord, in any case, my lord, it would be, my lord, everywhere, there is some, my lord, problem. If that, my lord, illegality affect, my lord, attacks the root of the, my lord, which, my lord, ultimately violates the fundamental right of the accused, and if then yes, my lord, accused is entitled to bail, my lord. There are from all these judgments, my lord, emerging, my lord, from Vihan Kumar, and before that also constitutional bench judgment is there that, my lord, although the my lord, regarding, my lord, furnishing written grounds of not that Vihan Kumar, my lord, that is the first judgment. Before that also, my lord, there are judgments. In fact, judgments of our honorable high courts also there, my lord, before that, my lord. And now, my lord, while, my lord, after Vihan Kumar, my lord, what happened? Everyone trying to find out, my lord, wherever fundamental rights violated, my lord, And at every point,
Earlier, it was not there, no? That was a two-line notice. That was what was followed. That's why I say,
yes, yes.
no quarrel with that.
And in fact, my
But
lord, one
if
interesting
it
point,
is
my lord.
violated now, then it is not defensible,
Yes, my lord.
especially in serious cases.
Yes, yes.
Then it is
And
not
while
defensible.
Pankaj Bansal, my lord, they say, my lord,
My learning window is almost over now.
yes, yes, sir.
I cannot afford, I am not expected to make those mistakes now anymore.
Yes, sir. My lord, for a moment, my lord, regarding, I would like to again, my lord, at the time of decay, law existing, my lord, at that point of time, my lord. Your lordship, I would like to again read, my lord, Article 22 of the Constitution, my lord. Already, your lordship,
Yeah,
for my satisfaction.
we
of
should
you,
read
my lord.
again and again, actually, always.
Twenty-one already, my lord, no person shall be deprived of his person. It is there. 22, my lord. I am reading 22 of the provision of the Constitution, my lord. I'm just pointing out how the Constitution was interpreted, and thereafter, my lord, furnishing written grounds of arrest, my lord, comes into existence. Thereafter, my lord, arrest memo. Protection against arrest and detention in certain cases, my lord, Article 22. No person who is arrested shall be detained in custody without being informed, my lord. No person on that particular day, my lord, my learned friend has, although I am not going to regarding Nazir's decision, my lord, I am not going into all those, my lord, things, my lord, at this point of time, because that will not anyway, my lord, help this honorable court to find out a solution, my lord. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall be denied the right to consult and to be defended by a legal petitioner of his choice. So only no person who is arrested shall be detained in custody without being informed. At that point of time, it is also not, their constitution also has not said that written grounds of arrest need to be furnished to the, my lord, accused, my lord. Only need to be informed. So therefore, my lord, at that point of time, my lord, no grounds of arrest, my lord, 10 grounds of arrest furnished to the accused persons. Only after, my lord, Bihan Kumar, and before that also constitution bench judgment is there, my lord. Although after Bihan Kumar, my lord, everyone, my lord, trying to, my lord, follow that furnishing of written grounds of arrest, because which itself says that non-furnishing of the same.
Because it was not made, it was not made prospective.
Yes,
So it
that
was,
is
it is
the
prospective only.
Yes.
So therefore,
Article 22
it will
only
be
to be,
there.
Article
Suppose-
22 only to be informed. Then, my lord, I would like, your lordship may kindly come to DK Basu, my lord. DK Basu was going to change.
See, most of the past cases where people have got benefit of this, many of these people I found, they have already been custodied for a long time.
But never at any point of time they raise any of
No,
the
because they
questions, my lord, any of the.
the fraternity also did not know.
Oh, yes.
It's a learning experience for everyone.
And my lord, frankly speaking, my lord, after, my lord, coming into existence of this, we have seen, my lord, in recent cases, my lord, there is somewhere, my lord, there is some defect in huge, wherein the huge contraventions are involved.
That will be very unfortunate.
That is, my lord.
Then that
it is difficult
that's
for
for
me to
police
say anything, my lord,
administration.
on this point.
That is why perhaps the latest decision, I don't remember the name.
Yes.
Which has come, no, about expressing concern about.
Yes, my lord, that is in the form of drug.
No, what is that decision?
Baldev Singh, my lord, I will also that judgment also.
Anyway, but say another aspect, before we proceed, I just make one point. The thing is that DK Basu indicates that this compliance with the arrest memo flows from the constitutional provisions, 21, 22, fine. So that means, in so many words, like Bihan Kumar, it has not been said, but that is, it has been, once it is linked to constitution, not following it will make it violative of constitutional provisions. And now we are clear that if constitutional provisions are violated, the continued detention is untenable.
Yes.
Okay. That's
And my
fine.
lord,
So now, after that, 36 was, these provisions were incorporated. Now, suppose we say that 48, in the context of 48, if 48 is complied, then part compliance of 36 will also do.
Yes.
Suppose we say that, won't it amount to diluting DK Basu?
No, my lord.
Because DK Basu still stands.
No, my lord, because why?
Forget that it's
DK Basu
it's
becomes, my lord.
a landmark decision.
Yes.
It's a very, leave aside that aspect.
Yes.
Only from precedentiary point of view, it is a judgment which holds the field, right? So since it holds the field, if we say that this will not necessitate compliance with 36, it will amount to diluting DK Basu. But do we have the authority to do that? That is the
Regarding that aspect, only Dorsan Kumar.
I'm
regarding
just thinking.
This, my lord, fact is there, my lord, regarding substantial complaints. And regarding, my lord, DK Basu, my lord, there is no dispute. I am not going to disputing anything about DK Basu, but DK Basu main objective behind, my lord, memorandum of arrest, my lord, ultimately on the basis of DK Basu, my lord, that provision of, my lord, memorandum of arrest is inserted in the by way of that statutory law, my lord. After, my lord, statutory law in this regard already formed. Now, my lord, that we will have to only go by the section 36C and my lord, other provisions of the, my lord, procedural law. So, my lord, all these aspects, my lord, again, your lord, 36, my lord, regarding, my lord, substantial compliance, and my lord, it can be said, although, my lord, not strict compliance because of the not, as per the, my lord, requirement that attesting witness is not there. That is only, that can be a procedure, my lord, irregularity. And regarding that aspect also, anyway, they have, they never raised that issue by way of that we are prejudiced that any harm caused to them. At no point of time they raised this point of time till now. Till now, while arguing before this honorable court, only saying will not do much.
You are applying prejudice test.
Yes,
That is
that is
substantial
also there, my lord.
compliance and prejudice test.
And
That is the
and
thrust
thereafter,
of
my
your
lord,
argument.
supporting all these judgment, three judgments of our coordinate bench and, my lord, division bench of the Calcutta High Court, while, my lord, 30, 47, 48 complied with 36 also, my lord, complied with, my lord, then, my lord, there is no question of violation of fundamental right. An aspect of, my lord, that my lord, NDPS cases, my lord, huge quantity of contraband, my lord, that is already there, my lord. And that Supreme Court judgment, Baldev Singh also, my lord, if, my lord, if all these in the form of drug abuse, if they are involved in, my lord, waging war against the nation, my lord,
That the Honorable
my lord-
Apex Court will have to take a call. We are not the last court, right?
But
So
at this point, I again
you have
pointed
to
out
follow.
because the judgment which was passed by one of the, my lord, honorable judge, who was there, my lord, at that point of time passing the Bihan Kumar judgment, he was also one of the, my lord, judge who, my lord, of Baldev Singh.
we are having to take up this because some different viewpoint on facts. You can there might be variation.
Yes.
On facts, there can be variation
Yes, ma'am.
between different benches. Ideally, even on identical facts, it should be same. One FIR, one court, ideally.
Yes, ma'am.
But well, on principles, you cannot vary. Actually, it has to be one principle, one court, one voice.
Yes.
Then only our law will be
Yes,
certain.
yes, my lord. So because of that, my lord, my first argument before your lordship, my lord, while conflicting decisions of our honorable high court is there. Suppose today, my lord, your lordship will have to support one of the view of the coordinate bench, and otherwise again your lordship will pass one judgment, and again all those matters will listed before before your lordship, my lord, and everyone will naturally, my lord, don't like to, my lord, do their cases where.
It will be highly unfair to the litigant.
Yes, madam. And which for the trial court will follow, madam. So, my lord, my argument at this point of time, because considering the admitted position, my lord, of this conflicting decision, this matter may kindly be referred to the, my lord, larger bench for, my lord, for getting a clarification, which will be helpful for all of us, my lord. And during the pendency of these cases, my lord, the petitioners cannot, my lord, regarding that issue, before taking any decision, they are not entitled for bail because of the gravity of the offense, considering the, my lord, that they are all are accused of.
Otherwise, in all the cases, 37 is hanging over the head.
Yes.
And it's very difficult thing to pass. Very difficult. Yeah, it may be possible sometimes. No compliance with section 50, suppose, recovered from body, then it may be. Otherwise difficult. Anyway.
And regarding Darshan Kumar also, my lord, that is paragraph 21. When may I read, or my lord, I will hand over to you, lord.
Prosecution seeks reference to larger bench.
Yes, my lord. Otherwise,
bench.
in fact, my lord, they
Quorum is
also,
more
my
than
lord,
one.
in fact, their argument also before one of the, my lord, Coordinate bench, my lord, that is, I will point out, they also seek for, my lord, sending the matter before the larger bench. In, my lord, BA number 986/2026.
I, it said, no, principle, on principle, it has to be one voice, of course.
Yes.
Otherwise, it will be confusing.
Yes.
It will not be fair. Okay.
Well, I've already submitted on the last date, my lord, so I'll not repeat any of it. Many of my learned friends are in line, my lord, in queue. So they will address this honorable court. A few points, my lord. I'll hardly take 2 minutes, my lord. The last point which my learned friend has just pointed out, that in a earlier bail application, this issue of reference was made. So, my lord, and a submission was made in the context of a different case. Arguments were made from both sides. At that time, this issue of reference was opposed by the state.
No, my
So,
lord.
my lord, let me finish. So that time this reference was not made, my lord. Now the state comes up and says that reference should be made, my lord. So the state should also have a uniform view on this matter, my lord. Now I'll come to the other aspects also. I'll just address few of the issues which my learned friend had raised. First is, my lord, regarding hyper technicality, my lord. My lord, the issue has been raised, flagged that this is a hyper technical issue, my lord. But a person's liberty has been curtailed. Article 21 is very clear that liberty can be curtailed only as per procedure established by law. And they have to follow the procedure, my lord. Now, when a person's liberty has been curtailed and he has been put in jail and the requirements of law have not been followed by them, in that case, my lord, they cannot brush it aside saying that this is a hyper-technical issue. And also, what it has been projected that there has been substantial compliance. Well, how can there be substantial compliance when the very essence of the arrest, which requires attestation by a witness, my lord, that is missing? It has been by and large projected that this dichotomy between 36 and 48 has been drawn up. But one thing which nobody really says is that, my lord, 36 never gives an exception to attestation. What 36 is says that it can be a family member or it can be a respectable member of the society. Here, the
Actually,
attestation,
taking an attestation at the time of arrest is very easy.
very easy, my lord.
Respectable member means every one of us is respectable. It's actually interpretation is that the person should not be tainted.
Yes.
Suppose somebody is his record is there in the nearest police station about some habitual, he will not be a respectable person. Otherwise, everyone else. Anyway.
And my lord, on the last occasion, I had pointed out regarding this by drawing this analogy with Caesar. Your lordship knows that Caesar requires independent witnesses, but the Honorable Supreme Court has said that where independent witnesses are not there, even police witnesses can suffice. So here in this case, if they did not even find a respectable member of the society, though it has to be reflected in the CD, they could have at least got some police constable to get it attested, my lord. But attestation is a must. Nowhere does 36 say that attestation can be waived. No exception has been carved out, my lord. And again, I submit, my lord, because 48 is brought in repeatedly. 48 happens much later, my lord. A 48 notice, this is at best will be post facto justification, my lord. A 48 notice cannot validate an earlier act which is not otherwise validated, my lord. Not otherwise valid, my lord. This is a subsequent act, my lord. How can the family member who has subsequently received a notice stand as proof as to how the arrest was made, in what circumstances the arrest was made? And one thing my learned friend has pointed out, that in all these cases, though other councils will address their individual cases, I can only speak for my case, that we have not taken this plea that there has been some violation, that this arrest has not been made properly. In fact, in this very case, the petitioner was taken in custody at night. He was shown to be arrested in the evening of the next day, my lord. So your lordship has already observed this in another case, my lord, and this flows from Kiran Singha and Niranjan Kumar, my lord, that the arrest is deemed to be done the moment the person is taken into custody. The person is kept overnight. In fact, in my learned friend's case, it's a lady, my lord, which the law does not permit to be arrested after sunset, my lord. That is done. But even if you leave all these issues aside, my lord, your lordship is deciding this issue on principle, not on individual facts. A question of law has been raised that whether 36 compliance of 36 is mandatory or not, my lord. So the issue will be decided on first principles, my lord. The issue will not be decided on the facts as to whether this plea has been raised or not, my lord. So they cannot get away by taking this plea, my lord. And this is one of the beauty of criminal jurisprudence, my lord. I do not have to do anything, my lord.
It is for them to do it, my lord. It is for the prosecution to do everything in letter and in spirit, my lord.
Subject to the reverse burden clauses wherever
That
applicable.
will be in the case of an evidentiary burden. Reverse burden clauses will be evidentiary burden, my lord. But the issues regarding registration from the registration of an FIR to the arrest of the person to his detention. Now, this bogey of a very serious offense, this drug menace is being projected, my lord. That has been contended by the prosecution, my lord. Now, in a case involving commercial quantity, if the prosecution does not complete the investigation within the stipulated time, can that argument sustain, my lord? It cannot sustain. 47, 48, can it sustain, my lord? It cannot sustain, my lord. So 36 will also not sustain irrespective of the gravity of the offense, because at the end of the day, as your lordship has correctly pointed out, it flows from DK Basu. And DK Basu in very unambiguous and categorical terms says that this is a byproduct of Article 21. So 22 would come much later, my lord. 21 is the first criteria, my lord, which protects the individual rights of every person, not just a citizen, my lord, every person. So they cannot get away by violating Article 21. If anybody is to blame, it is the arresting officer who is to blame, my lord, because he has not complied. Now, because of his non-compliance, if a right accrues in our favor, my lord, we are entitled to take that right, my lord.
Yes, definitely.
Well, we will seek that right, my lord. Just because the offense is
losing his liberty will definitely look for a way to get out.
My lord.
Certainly.
Because that is his right.
No
And-
quarrel, no quarrel with that.
Yes. And my lord, regarding Baldev Singh's case, which my learned friend has pointed out, because my lord, Article 21, the periphery of its jurisdiction is very large, my lord, and much water has flown under the bridge regarding
21,
Article 21.
21.
So here in Baldev Singh's case, one of the contentions was regarding prolonged incarceration. This is not the contention here. Secondly, this person was accused in 3 cases, Baldev Singh. And most importantly, while inside the jail,
Baldev Singh, the recent one.
the one where this issue of the sovereignty of the state prevailing over that issue had brought up, my lord. Yeah, because he was running a drug racket
The
inside the
Bihan
jail.
Kumar principles will apply to UAPA also, I think.
Yes, my lord.
No
because
exception has
no
been
exception has been carved out, my lord. So this principle, so Baldev Singh is very
Exception can be made tomorrow
Yes.
with justification, but so far it has not been done.
So when my learned friend is seeking a reference, man, whether the reference is made or not, it is obviously your lordship will take a call on that, my lord. But my respectful submission is that in this context, there is a Supreme Court judgment which is binding for everybody. Now, even if, in spite of the fact that a coordinate bench may have taken a different view, my lord, but at the end of the day, that DK Basu cannot be ignored, my lord. When it is clear and unambiguous, my lord, that this is a byproduct of Article 21, and Subhash Sharma makes it very clear, though Subhash Sharma need not have said it also. But it is understood, my lord. Everything does not need to be written in black and white, my lord.
But it's good
Some
it
things
is
are
said
understood.
sometimes
Yes,
clearly.
yes. But
What
Subhash
was
Sharma has made it
Subhash Sharma
clear, my lord.
para was there.
Yes. So Subhash Sharma, and the issue of this, my lord, this being interconnected, obviously, my lord, every aspect is interconnected. Arrest is followed by detention, remand, detention, trial. Well, obviously, everything gets connected. But when there is in the requirement of individual compliance, my lord, so just because a subsequent post act is done, my lord, subsequent act is done, the earlier one does not get validated, my lord. So my respectful and one more thing, my lord, regarding Darshan, my lord. In my compilation on the last occasion, because Darshan was not pleaded, my lord, Darshan has already been distinguished by division bench of this honorable court. In my lord, paragraph page 55, my lord, of my compilation.
Maite, Thangling na Maite.
Yes, my lord. It's been very clearly laid down, my lord. And in fact, the other case which your lordship was part of that division bench, my lord, this issue in the concurring opinion, my lord, this issue of prejudice has been very clearly laid down. When prejudice is caused, when a person has been arrested without complying with the necessary safeguards, my lord, he is put behind bars, my lord. He has lost his liberty. No further demonstration of prejudice is required to be given, my lord. That is very clear in my lord, Hemkholal Mate, my lord. Rest issues, my lord, my learned friends will address, but my respectful submission is this, my lord.
No, only one aspect I would like to that on I'm trying to that regarding Article 22 of the Constitution regarding violation of not production of the equity within 24 hours. One of the judgment of our recent judgment of our coordinate bench of our High Court, my lord, wherein Subhash Sharma and my lord Niranjan Singh and another was also my lord cited, my lord. I am just reading only 2 lines, my lord. As regards the second contention of violation of provision of Article 22 of the Constitution of India is concerned, it appears that though the petitioners were arrested on 13/12/24, that is more than 1 year, 5 months ago, however, it is for the first time in the instant bail application, they have raised the plea that at the time of arrest mentioned in the arrest memo, that is on 20 hours on 13/12/25 has been wrongly mentioned therein, and that the actual time of their arrest is 12:45 hours. Again, this court has no second opinion as regards the legal proposition that in the arrest memo, the date and time of actual apprehension of an accused has to be mentioned. The meaning of arrest is to take a person in custody. It means that the law has taken control of such person and he is in physical hold of an arresting authority with coercive power. The practice of showing incorrect time in arrest memo can never be encouraged for whatsoever reason, as it tends to defeat the constitutional protection granted to an arrested person. This is important. However, as to what was the actual time of putting the person under lawful restraint so that he may be deemed to be in custody is a question of fact. And same has to be determined after considering the fact and
question of
circumstances of
fact.
a particular case. So in this case, after a long period of time, they raised that they are prejudiced by that by inserting that time of arrest is and thereafter production that after a long lapse of time. So this honorable court, after discussing Subhash Sharma and Niranjan Singh and Prabhakar Raja hold that is a question of fact. And after a long lapse of time, this point was it. So
It was not allowed.
this honorable court has not rejected the bill.
If it's a legally valid point,
Yes.
I don't think I can question that why it was not raised earlier. I mean, not be something like a, delay. Anyway,
Otherwise, fundamental right of no one is absolute. If you want to enjoy your fundamental right.
If it is in clear terms, then it is there will be lesser mistakes ultimately
Yes,
at the
yes.
level of IO.
Yes, yes.
There should not be many ifs and buts.
Yes.
Then for all law, but generally, especially for these kind of things, lesser the ifs and buts,
Yes.
more clear will be initially there may be mistakes, but then they have to be, it can be told clearly that this is what you have to follow and you are accountable for it.
Accountable.
Anyway, sorry.
Within 24 hours, you will have to complete this proceeding. Otherwise,
It is challenging, no doubt, but these things are not excusable. Not taking, I would say the IO was lazy. Taking
why all
that
these-
time frame is a challenge, completing all procedure and that's challenge, but taking signature of a person, who will refuse? The police says that you have to put a, who will
It's
refuse?
difficult for me to argue regarding motive part, why this happened, ultimately benefit goes to the accused. This some of the things is there, at this point of time. It's difficult.
At the end of the day, this IO has not done it, my lord. The state machinery has failed.
But at this point of time, here in all these cases, it cannot be said that IO has not done everything. Only regarding that,
Some information.
that witness is not
Some information.
there.
Some information.
My lord, let me
Yes.
Your Lordship, I have given one citation, Lordship. Lordship, may I kindly have a look. This judgment was authored by Honorable Justice Mr. A.S. Oka, who subsequently was elevated to Supreme Court, and while sitting in Division Bench of Bombay High Court, this judgment was authored. So now, Lordship, may I kindly say paragraph 4 that DK Vasu judgment was quoted. So I am not reading those part. This Your Lordship has read number of times. So then, Your Lordship, may I kindly say paragraph 5. Here, 41B, that earlier CRPC, that was quoted. And now paragraph 6, Lordship, may I kindly see. May I read, Lordship?
Wait, let me write down the paragraph.
4, 5, and 6. Lordship.
6.
Thus, the legislature has now incorporated the guidelines laid down by the Apex Court in the case of DK Vasu in the said code in the form of section 41B. Admittedly, there is no separate memorandum of arrest of the petitioners drawn by the police. A register has been maintained at the police station, which is described as the register of showing compliance with the direction of the Apex Court in the case of DK Vasu Supra. There are columns therein such as the name and address of the persons arrested, time and date of arrest, and the offense alleged, names of the investigating officer and the officer of the police who arrested the person, names of the relatives of the arrestee who have been informed about the arrest, signatures of the relatives or friend of the arrestee, and signature of the arrestee. The mandate of the direction of the apex code in the case of DK Basu Supra as well as section 41B of the said code requires drawing of a separate memorandum of arrest in case of arrest of an individual. The practice of maintaining such a register without drawing a separate memorandum of arrest is not consistent with the direction of the apex code in the case of DK Basu Supra and the requirements of section 41B of the said code. The register can be in addition to the arrest memorandum. Therefore, as the directions issued by the apex code flows from Article 21 and 22 of the Constitution of India, breach thereof amounts to violation of Article 21 of the Constitution of India. So here what they are saying that I have given the grounds of arrest in writing to the family members, so that will suffice under section 36. That will not. Because they have to prepare a memorandum of arrest separately by following the provisions. And just I am placing that Lordship, section 36 once again, Lordship. What I am pointing out from section 36, Lordship, may kindly have a look at section 36 once. That the heading is procedure of arrest and duties of officer making the arrest. Two parts are there. One relates to arrest and other is duty. Now, the subsection A and B are the procedure of arrest. And second C, that is the duty of the officer to inform the family members. And there on C, Lordship, I am just pointing out one aspect. 36 C.
Yes, I am on that one.
Lordship.
Yes.
Inform the person arrested. So first part is inform the person arrested. Unless the memorandum is attested. So what is the memorandum? Memorandum of arrest. So even if they say the signature of family members are there in the 48 notice, that will not suffice. Because section 36C says signature has to be there in the memorandum. And that part will come when, Lordship, it was not informed to the person. Is attached by the family member of his family that he has a right to have relative or a friend or any other person named by him to be informed of his arrest.
Yes, I get it.
And in this, the judgment, the divisionment judgment which I have given to your Lordship, that subsequently held that as their register was maintained without preparing the arrest memo, that was held to be illegal, Lordship. That paragraph your Lordship will find.
This paragraph.
And in fact, in paragraph 14 also that compensation was granted.
And paragraph 9 is relevant, where arrest has been held illegal. Paragraph 10, it starts from 10. Last part, arrest is legal.
And paragraph 10, last part it is held that the arrest is illegal, Lordship.
Yes, yes, sir.
Because no separate that memorandum was prepared, Lordship. Last line I am reading of paragraph 10, Lordship.
Last line of para 10.
Lordship. Para 10, last line, Lordship. That will do. Thus, there is breach of directions issued by the apex court in the case of DK Basu. Thus, the arrest of the petitioners is rendered illegal. And in fact, in paragraph 14, compensation was also discussed, Lordship. Hence, this court is empowered to grant compensation in this petition under Article 226 of Constitution of India when violation of Article 21 is clearly established. So I am not on that, ultimately 20,000 was granted. But what I am submitting to your Lordship is that the grounds which are mentioned in the DK Basu guidelines which are mentioned in the DK Basu judgment flows from Article 21. That those directions may have been incorporated in CRPC or BNSS, but those derive its power from the Constitution, Lordship. If that is violated, Lordship, that will amount to violation of Article 21. And in fact, that itself in DK Basu itself, Lordship, that in paragraph 38, it is held that it flows from Article 21. That is, there is no dispute on that, Lordship.
That was what I was saying, that flows from, it has
And
been held to be flowing from that, and that's.
Yes, and that is also
still there.
Yes, that is reflected in the judgment which I have placed before Lordship, paragraph 4. Last part, it is that guidelines are there. Paragraph 36 and 36, 37 and 38 are also quoted of DK Basu. These requirements are in addition to the constitutional and statutory safeguards and do not detract from various other directions given by the courts from time to time in connection with the safeguarding of the rights and dignity of the arrestee. So these are in addition. And in paragraph 37, it is the requirements referred to above flow from Article 21 and 22(1) of the Constitution and need to be strictly followed. These would apply with equal force to the other governmental agencies also to which a reference has been made earlier. And regarding my petitioner lordship, that I have one additional ground that she being a lady, she was kept in police station for whole night and subsequently on the next day she was shown to be arrested. Now, if your lordship,
Your bail petition was item number?
item 24. Now, lordship may kindly see page 23 of my petition.
That is, according to you, that is another violation of arrest procedure.
Yes. Now, here your lordship may kindly see that arrest memo I have annexed at page 23. Here, time of arrest is once lordship strike out, then subsequently
For that, my lord, that matter has to be separated. I will have to check the record.
No, it is there. I am also placing that how I am prejudiced.
Arrest was it?
As per FIR, I was arrested on lordship 26/2/2026 night.
And those expressions like sunset and sunrise have also
Sunset,
become outdated.
Yes, they have to obtain permission.
Timings have to be
timing,
given.
yes.
Sunset in Mizoram is different from sunset in Bombay.
No, here 9:30, that timing is.
Time
not-
has to be.
Yes,
No,
9:30.
the law has to indicate timing.
Yes.
Like within what time it is
Yes.
not, it's prohibited
That is
at night.
night.
At least they've written, frankly, it's
Right.
at night.
Right.
Probably they were not aware, it seems. Maybe.
Probably they are more aware because they have lots of given a different time in arrest memo from the from the FIR lordship.
Later they came to know.
Arrest memo, your lordship will find that 1:15 is written, but again in 47 notice they have written 1:30 PM. So there are discrepancy in timing also. If it is 1:15, they have to write it 1:15. If it is 1:30, they have to write it 1:30. Now, who will verify this aspect that I was arrested at that point of time if witness is not there?
Anyway, so next.
And next lordship, your now just because of that various judgments of coordinate benches lordship on different aspect. Now, what my submission to your lordship is that similar issue arose before coordinate bench while dealing with a bail application. That earlier point of time, that honorable court held that 36 is mandatory. Subsequently, different order came. Now, what in this coordinate bench did, just I'm placing before your lordship. So, about the video. Yeah.
This is part of the compilation?
No, lordship, this is subsequently
different.
lordship.
Para 11. Difference to para 11.
This bail was allowed.
Lordship. Here, lordship, for heaven, lordship may kindly say paragraph 11. Paragraph 11, lordship may kindly say. That other cases were discussed and this coordinate bench held that the order passed by that coordinate bench was passed at earlier point of time. So that will prevail. And that is the law in my humble understanding also that because of that pronounce judgment also. The earlier judgment which was passed and if not considered by the coordinate bench subsequently, that law will prevail, lordship.
It will distinguish from this. 119.
And that specific finding, your lordship will find paragraph 12. Order observation. After discussing various orders, it is held from, may I read, lordship? from the aforesaid, this court has already decided the issue that the compliance of section 36 of the BNSS shall make an arrest illegal, though there is compliance of section 48 of the BNSS. It seems, while considering the case of Jabbar Hussain or the case of Abu Sama and other decided on 2/12/2025, was not placed before the coordinate bench of this court. And in fact, your lordship's order is also there, which was passed probably in the December 2025.
26/11. 26/11/25.
26/11/25. That was also earlier point of time.
That is the.
I'm just placing that 3375.
3373.
Sir, 3373 lordship.
Abu Sama Lord. এটা আছে। এটা আছে না।
That case number, I'm just placing that order, lordship. That at the, this was the earliest point of time, lordship.
37. It's okay. 37.
So if that order was not placed before this honorable court, then
It was passed in 26.
this is your lordship's order. Yes, yes. 26/11/25, this order was passed.
Actually, in Pranay Sethi, when I looked up this thing, the Pranay Sethi actually deducted that principle from an earlier decision.
Yes.
If you see that para,
Lordship, that I'm placing.
yeah, it referred to an earlier decision where this was said
Yes,
that if two benches
yes, that
are
paragraph
equal,
18,
then
yes.
the earlier one point of view, it is indicative, but not in so many words it has been said, but
Paragraph 18/19.
let's come to that. They approved the Patna High Court
Lordship.
decision
Lordship.
approach, and then
No.
when they discuss this. This only, in Pranay Sethi, only this earlier old decision laying down this principle was approved,
Yes.
the 1962.
Yes, yes. So ultimately, your lordship's order was passed earlier point of time and other coding, so that probably will prevail.
No, the thing is like that, either I follow or I disagree, then it has to be referred.
Yes, your lordship, that here what it is said.
One can disagree, but
Yes,
it has to be.
yes, that
Otherwise,
earlier
there will be
order has to be
chaos
followed
and
or it can
confusion.
be referred to the decision.
একদম নোট রেডি আছে ডিসকাস করুন এবার দিস ইজ ডিসকাস সেকশন 40 30 সেকশন 50
And one more judgment, lordship, of coordinate bench, where lordship section 36 and 48 separately has been discussed, lordship.
এটা নোটস আছে তুমি মুখ হয়ে যাও আমাকে এটা
Paragraph 36 and 48 of what court follow?
ইয়া করা স্টার্ট হবে কোর্ট রেফার টু প্যারা প্রথম দিকে বাসু দেন প্যারা 15 কাম 15
Then first, your lordship, may kindly see that BA number 1199 of 2026, Jubair Ahmed, which I have given just now, lordship. First, paragraph 14. The paragraphs of DK Basu, which we have just now read, lordship, that paragraph 37, 38 and 39 are quoted at paragraph 14. Now, paragraph 15, in view of the aforesaid directions in the case of DK Basu, certain amendments have been carried out in the Code of Criminal Procedure 1973 by way of inclusion of section 41A, section 41B, 41C, and section 41D, right the Act of 2009, with effect from 1/11/2010. Section 41B of the CRPC laid down the procedure of arrest and duty of the officer making the arrest. After coming into effect of the BNSS, section 41B has been inserted in the BNSS 23 as section 36. So 36 is quoted, that I am skipping, lordship, paragraph 18.
18 also skip read now 22
22, lordship, may kindly come to paragraph 22. it is seen that section 50A of the CRPC corresponding to section 48 of the BNSS was inserted in CRPC by Act 25 of 2005 with effect from 13/6/2006, 23/6/2006. Therefore, it is clear that section 50A of CRPC was already in existence when section 41B of CRPC corresponding to section 47 of BNSS as inserted with effect from 1/11/2010. Therefore, it cannot be denied that while inserting section 41B into the CRPC, the legislature was aware of the existence of section 50A therein, and section 41B was inserted with such knowledge. So it can be said that though the mandate of under section 50A was already there, the mandate under section 41B has been included in the CRPC independently. This shows that both the sections 41B and 50A are two independent provisions which requires to be complied with independently. After coming into effect of BNS 2023, accordingly, section 36 and section 48 of BNSS are required to be complied with by the police authority while arresting an accused person.
No, 25.
Now 25, Lordship Magali said, therefore, a combined reading of aforesaid section of 36, 48 and 62 makes it clear that while arresting an accused person, the provisions of section 36 as well as section 48 have to
Clearly
be,
said,
Lordship.
very clearly it says. As far as this code is concerned.
27 is important. For discuss the nature and intent of 48 and 37. 27, 29, and heading 31.
And I am referring the paragraph, Lordship, 27, 29
and 31.
and 31, Lordship. And 27 is relevant, more relevant, Lordship. May kindly see that paragraph 27.
27, 28.
Yes, 27, 29 and 31. 27 is also important, Lordship.
Nature and intent of both the sections.
Yes.
How it is different, 48 is different from 36, that is described.
Good job. Vince.
It will 30 hours help for it has to, it cannot be read. 30 paragraph 30.
So my submission for Lordship is that from DK Vasu, it is held that these are Lordship constitutional right of an arrested accused. So whether if there is Lordship coordinate bench, different judgment is also there. But if your Lordship sees that there are violation of my constitutional rights, then probably Lordship coordinate bench judgment will not come in the way, Lordship. Because your Lordship will follow that DK Vasu judgment, which says that these are constitutional rights, Lordship.
Okay.
And just one prayer, Lordship, if your Lordship sends this matter to larger bench, Lordship, to decide the issue. In that case, as your Lordship have already held in earlier decisions that these are Lordship mandatory in nature. So in that case, Lordship, we may be allowed some interim protection because it may take some time while deciding the issue, Lordship. And during this period, they will not be able to file any bail application before this honorable court or any other court, Lordship. They will remain there. So interim prayer that may be considered. Because the order which is passed by your Lordship at the earliest point of time, that has not been challenged by the state till date. There may be the Lordship different view now, but that order has not been challenged by the state till now, and that has attained finality, Lordship. And even coordinate bench also not said that those judgments are not applicable, Lordship. That part is there. So considering that, Lordship, interim prayer may be considered if it is sent to larger bench.
52
Regarding one.
And regarding Lordship, item number 52, I have similar submission, Lordship. Supplementary 52. And only in regard to item 24, Lordship, that 46 for
43 for BNS. Now 43 for.
Just a minute.
46 4.
No, 44. It is saving except 43. Saving and no mention various rata sunset.
Item?
item 24, Lordship,
Mhm.
that 43 subsection 5, Lordship.
The sunset.
Is sunset,
See.
that part, that additional subsection. And item 52, Lordship, that other 30 regarding 36 is same, Lordship.
Mhm.
Submission.
Yes.
All right.
Regarding my lord, one of the division bench of the my lord, Bombay High Court cited by my learned friend, my lord, that judgment paragraph 6, my lord, that is not at all applicable in the present case because
Which judgment?
in that case, my lord, that my lord, one judgment, my lord, honored by Honorable Justice A.S. Oka and S.S. in the
Bombay High
of the Bombay High Court, my lord.
Okay.
That
Mm.
paragraph 6, my lord, in that case, my lord, the police has maintained one register in the
Ah.
form of memorandum.
There was
of
no,
right.
no,
In that
there's no
register,
form also.
Yes, no form. So that judgment is.
It was easier to decide comparatively.
In fact, Lordship, in that case, Lordship, it is better, our case is better. Because in that case, witness signature was there in the diary, Lordship. And everything was followed,
But it was not in the form.
not in the form.
What is next?
Yeah, Lordship.
Item.
my item is 53, Lordship. And regarding 36, Lordship, this is the 36, 53. 36, 48, both are standalone provision and partial violation or complete violation of fundamental rights is not permitted in the Constitution of India. Lordship, Section 36 and 48 both are separate, which has been held in the landmark judgment of Bihan Kumar in the
Okay.
Yeah. The Lordship is in the page number 32, paragraph number 26, Lordship. Bihan Kumar's. I have highlighted the paragraph first.
Okay.
Relevant part. Yes, I'm perusing, Lordship.
Para
In-
20. I'll go to para 26.
Yes, Lordship.
Yes, you have highlighted.
Yeah. Information about the arrest is completely different from the grounds of arrest. The grounds of arrest are different from the arrest memo. The arrest memo incorporates the name of the arrested person, his permanent address, present address, particulars of FIR, section applied, place of arrest, date, and time of arrest. The name of the officer arresting the accused and name and address and phone number of the person to whom information about arrest has been given. We have perused the arrest memo in the present case. The same contains only the information stated above and not the grounds of arrest. The information about the arrest is completely different from the information about the grounds of arrest. Mere information of arrest will not amount to furnishing grounds of arrest. Is the completely different 37, 36, and 48 arrest memo and grounds of arrest are completely different, Lordship. So it cannot be amalgamated both the provision together. And in regarding my case, Lordship, the item 53, the one more provision violation is there, which is in the page number 26 of my.
Yes, you can submit.
Page number 26, that the grounds of 48 notice has been served on the one Amiruddin. But who is Amiruddin? How is Amiruddin identified? No acknowledgement from the taken from the nominated person, or whether he understood that notice or not, that has not been explained in the notice, Lordship. Lordship, this is 48
if I come to the BNSS section 48, Lordship, Lordship, section 48, subsection 3, Lordship, may kindly be. An entry of the fact as to who has been informed of the ground of the arrest of such person shall be made in a book to be kept in the police station in such form as the state government may by rules provide. That means the GD entry or any record has to be made, has to be available in the police station, Lordship. But regarding my nomination of person Amiruddin regarding my arrest, I didn't nominate him, neither I know him, neither the nominated person knows me, Lordship. So, and in the next paragraph, the separate page, the grounds of arrest has been given, but no acknowledgement that the nominated person has understood the grounds of arrest or not. Nothing has been mentioned in the page, Lordship. This is in Hindi, Your Honor. And the Amiruddin is from Karbi Anglong, Difu, Your Honor, Lordship. Then, whether I have understood this or not, nothing has been acknowledged in the page, Lord, in the page 27, Lordship. Nowhere it is mentioned, Lordship. And the how the nominated person has been identified, that is also not explained in the case record, Lordship. So this is the violation of 48 also. So fundamental rights, first violation is 36, which is arrest memo, and next, second violation is 48. So both are the standalone provision and fundamental rights has been violated. And already I have mentioned in the Bihan Kumar's paragraph 26 that arrest memo and 48 both are separate. They're not 36 is not the substitute of section 48 notice, Lordship. And regarding this, our coordinate bench of High Court, some of the orders are there, bail order. Is page number 4,
Of which one?
paragraph number 6, page number 4. I have highlighted them.
No, it could be like, no? This is been given by prosecution, I think. Anwar Hussain Chaudhary.
Yes, Lordship. May I peruse, Lord?
Yes.
Yeah. It is not in dispute that in the case of NDPS Act, in paragraph 6, Lord, page number 4, second part.
Got it.
It is not in dispute that the case of NDPS Act, also the provisions of arrest a person as laid down in the BNSS 2023 must be complied with. For the purpose of the present case, section 36 and section 62 of the BNSS being relevant are quoted here. 36. Procedure of arrest and duties of officer making arrest. Every police officer while making an arrest shall bear an accurate, visible, and clear identification of his name, which will facilitate. Yes, Lord. Then last part, it's mandatory. It is said in this is mandatory, Lordship. So I am not repeating the same again.
Yes. True.
Then it's one more coordinate bench judgment order, bail order.
Lordship, page number 6, Lordship,
Para?
para 13. I am not repeating the section provision. This is page number 6, Lordship. Paragraph 13. A conjoint reading of the aforesaid two sections makes it clear that a memorandum of arrest is a written document that serves as confirmation that the individual in question was arrested. In addition to meeting the essential requirements, it must provide particulars that are specific. A minimum of one witness is required to vouch for its authenticity. For the best possible outcome, this witness ought to be a member of the accused person's family, and in the event that a family member is unavailable, a respectable individual of the locality in which arrest is made may be called upon to testify as witness. In the second step, of course, the arrest person is required to countersign the arrest memo. Paragraph 14, Lordship. What is discernible from the aforesaid two sections that there is mandate provided by the aforesaid section 36 that arrest memo has to be signed by a witness. Either he is a member of the family of the arrested person or a respectable member where the arrest is made. Section 62 provides that no arrest shall be made except in accordance with the provisions of VNSS or any other law for the time being in force providing for arrest. Therefore, any arrest that has to be made is mandatorily has to comply with the provisions and procedure of arrest while making such arrest. Non-compliance of such provisions will be violation of the mandatory provisions, which will in turn make such arrest illegal. Once an arrest becomes illegal, the arrested person shall have an unfettered right to be set at liberty, that is to be released on bail. Lordship, then paragraph number 16, Lordship. In the instant case in hand, it is seen that the arrest memo does not contain any signature or attestation of any person, neither of a member of the family of the arrested person or of any respectable family of the locality wherein the arrest was made. This clearly violates the mandate of section 36, read with section 62 of BNSS. Additionally, no material could be found as to whom the notice under section 48 BNSS was served. No name of the address could be found in that. That is a little bit different from my case. My case is that it is served, but on the nominated person, whom I don't know. Lordship. Then paragraph number 18, Lordship. In view of the ratios laid down by the Honorable Apex Court in catena of cases as well as the procedural mandates laid down under section 36 of the BNSS 2023, this court is of the considered opinion that there is a violation of 36 of BNSS 2023 in the instant case while arresting the accused applicant, whereby curtailing his fundamental rights granted under Article 21 and 22 of the Constitution of India. So, Lordship, so section 36 violation in part, either it's partial or it's fully. It is not permitted by the Constitution of India, and both 36 and 47 are standalone provisions. So there are ample grounds for granting the bails of my of this accused person. Obliged. May I please your lordship? My item is 25.
Yes, only 25.
25. My lord, so long we have been listening the violation regarding the importance of the protection of the accused, my lord, as provided in the Constitution. Now, your lordship, my lord, page 23 of my petition, your lordship will find there is a memo arrest under 36, but your lordship will be surprised to see there is no attestation of the any independent person, my lord. Page 23, Annexure 3.
Item
25.
25.
Page 23, Candice. There is no signature
Yes, I remember now.
of the any independent person. Then, my lord, page 24 also for another accused person, there is no signature. Not even. So 36 is violated in for both the accused person. Then, my lord, if we come to the arrest memo, your lordship will find page 38. Page 38, arrest memo was sent for
No,
sent
that's
wrong
not-
mind.
Am I taking the right file? It's your eyes, item 25, no?
25.
25.
Yes.
Item 25, page 38 is 48 notice.
48 rules. It was sent to Method Rongmai in Manipur. And the language has been used in English and Hindi, my lord. Whether this man is conversant with the other language is very doubtful, my lord. There is no indication that it was explained to him and he understood it and received by one Matthew. I do not know who is the Matthew. Then, my lord, next petition, your lordship will find another co-accused by 48. It was also, there are two accused, my son. It was received by Matthew. I have not nominated any Matthew, my lord, and I do not know even. Rongmai is from Manipur. He's a Naga, my lord. Matthew Rongmai, and the other the accused are all from Manipuri. They knew the Manipur language, but they given it in their English. And my lord, learned special judge, page 47. May I take it to page 47? We have raised this point before the court below. And now how the learned court below has justified his action that 36 is not required. Page 47. May I read, madam? Page 47. Below, during the course of hearing, it is submitted on behalf of the bail petitioner that the accused persons were apprehended on 21/2/26 and have been continuous judicial custody from 22 to 26. He was shown arrested. It is further submitted that mandatory procedural safeguards of BNSS have been violated inasmuch as arrest memo under 36 is not attested by any independent witness or family member as required by law. And notice under section 48 was not duly served upon the relatives of the accused, nor does the alleged notice bear proper acknowledgement, thereby violating the arrest itself. Visiting the arrest, learned counsel submits that such non-compliance of 36, 48 and BNSS dilutes the rigor of the section 37 of the NDBS Act. Therefore, it is prayed that the accused person be enlarged on bail. What is the order of the court? Perusal of the case records reveals the connection of the case recovered on 1.125 kg of Yaba tablets of FSL reports revealed that the samples tested positive. From the case diary, it transpired that the accused persons were arrested on 22.
This is the other view.
Yes.
This was not essential.
No,
It will not vitiate.
Yes,
If 48
is not vitiate.
If 48, since 48 was given.
Yes.
That is what this.
So, my lord,
This is the other view.
my humble submission, it is not a proper explanation or proper law.
It's not correct.
He has wrong conception is there. He has not considered the D.K. Bosu the historic judgment, my lord, where it is said that arrest memo is strictly necessary to prevent police arbitrariness, documents the exact time, place, or the arrest established accountability, and to ensure the detainees family can be promptly noticed. Then, my lord, the important line of the D.K. Bosu's case, it is in addition to the statutory and constitutional requirements to which we have made reference, we are of the view that it would be useful and effective to structure the appropriate machinery for contemporaneous recording of the notification of all cases of arrest and detention to bring in transparency and accountability. It is desirable that the officer arresting a person should prepare a memo of his arrest at the time of arrest in the presence of at least one witness who may be a member of the family of the arrestee or the respective person of the locality from where the arrest is made. The date of time arrest shall be recorded in memo which must be countersigned by the arrestee. Now, my lord, this idea of 33 has come from D.K. Bosu's case.
Okay.
So we cannot overlook the D.K. Bosu's guideline. There is a guideline mentioned that even a contempt can be drawn against the person if he violates the provisions of the provision of law. So, my lord, here another aspect is that in the seizure list it has been Yaba tablet, but in Panchanama it is, my lord, ganja. The court has said that it,
Yes,
Huh?
this is the separate content.
Hmm?
No, only second.
Pardon?
The other is the one of the second.
So, my lord, what I pray that regarding 36 matter, our court has already considered several judgment methods which has been placed before your lordship. I do not want to burden your lordship, but only I want to place 2, 3 of the similar views. Right. But it is the contention of the petitioner. I have placed my petition, our own High Court judgment, my lord. It is the contention of the petitioner that para 10, my lord. Non-communication of the grounds of arrest in a violation of 51 CRBC corresponding to 47 of BNSS, rendering the arrest of subsequent remand of the arrest petition invalid. The accused petitioner has the fundamental right to statutory right to be informed about the ground of arrest in writing, and copy of the such written grounds of arrest have to be furnished to the arrested person as a matter of course of without any explanation. No non-supply of the written grounds arrest to the arrest person. Then it has been held by the Prohibitions case, my lord. Then, my lord, our coordinated bench has referred the para 12 Bihan Kumar. The requirement informing the person arrest of the grounds of the arrest is not a formality but a mandatory constitutional provisions of the law. It includes the part 3 of the Constitution heading the fundamental rights. This is the fundamental rights of every person arrested and detained in custody to be informed on the grounds of arrest as soon as possible. They were arrested on 21, 20, arrested on 21, 25. They are produced on the next day, my lord, at 10 a.m. They are shown arrested at after almost 12 hours, my lord. The ground of arrest not informed as soon as may be offered. No person shall be deprived of his liberty except the according to the law, procedure established law. The procedure establishment law also includes what is provided in Article 22(1). Therefore, when a person is arrested without a warrant and the grounds of arrest are not informed to him as soon as possible after the arrest, it will amount to a violation of the fundamental rights granted in Article 21. So accordingly, my lord, our coordinate bench has granted bail. Then, my lord, another judgment I have placed to your lordship. By my lord Justice Justice Shoikia. My lord, here in case in this earlier it was rejected by once, second time it was filed by giving a provision of law that by giving the reference to Bihan Kumar para 4, my lord, your lordship will get para 4. The petitioner arrested by police, he was given the opportunity to talk to his wife over phone. At that time, the court held that the provision of law under section 47, 48 were complied with. Today, Mr. Mahajan has submitted that mandate of Article 22(1) Constitution of India speaks of the written communication, not of any telephonic communication, referring to Bihan Kumar, state of Haryana. Mahajan has submitted the requirement of the communication grounds of arrest in writing, not only to the arrested person, but also to the friends, relatives of such person, and may disclose the nominated person. Here, my lord, grounds of arrest was not given, and not my, no relative was signed, my lord. Even my signature also not there. So, my lord, it is a out and out violation of the provision of 36. So, I pray that your lordship will kindly consider this method. And my lord, along with the other submissions submitted by my other friends, my lord, only regarding violation of these cases 36, I hope, my lord, your lordship will definitely give a serious thought about the matter, because of there is a difference of opinion by honorable courts in 3 court has given in our favor that 36 is a mandatory provision of law, and violation of its amount to a fundamental rights, and given the benefit to the accused persons. Then, my lord, here my case, my lord, no trial was started till today. Though I was taken into custody, my lord, in the year 2025, 25, my lord, and I am behind the bar, my lord, 124 days. Charge sheet has been given, but nothing has been done till today. In this case, my lord, your lordship will find from the FIR, the Indian Naka checking, they were taken, they were found on the road while they were carrying the contrabands, my Alice contrabands. That was at the time of, my lord, on 21 to 26, at, in the Jarighat PS Naka checking, and they were immediately taken to their police station, and next morning they were shown arrested at 10:30 p.m. my lord. And they were interrogated at the police station night, and seizure was also made in the police station. Arrest memo also showed that they were arrested on 22/2 at 8:20 a.m. my lord. But they were apprehended in the one night, earlier night, my lord, evening, 6 p.m. Then, my lord, my prayer that the paramount consideration of the DK Bosu, we cannot ignore the guidelines given regarding arrest. There should be legal, lawful arrest, my lord. Illegal arrest cannot sustain under law. So, my lord, no doubt, my lord, NDPS cases are very serious in nature. There is a question of national interest because of the war. This is a kind of war against the carry out against this practice of contraband goods, my lord. But at the same time, the constitution is very clear that every individual's right is to be protected. No one should be detained illegally.
Okay.
So, with this submission, my lord, I once again pray to your lordship to consider my case, and he is entitled for bail as it is a violation of his rights. Arrest memo was illegally done, and 48 has not been followed. And regarding hypertechnicality, my one of friend has already submitted. It is not a hypertechnicality, my lord. It is a very serious matter. And, my lord, in the DK Bosu's case, Supreme Court has sent forwarded the judgment in every chief secretary and DGP of the state, all state and union territories, to compliance for the full compliance of the DK Bosu. So, my lord, unless your lordship is given a serious thought over the matter and give a second time guidance to the guidelines to all the police stations and the SPs of the DGP, they will continue to violate this provision of 36. They will not follow. They have got the right to arrest any person, my lord, if they are found with anything illegality or contraband. But law is very strict that it should be followed, so that one cannot raise or say that his fundamental rights is vitiated, because our constitution has given a paramount constitution to protect the fundamental rights for each and every individual. This is my submission, my lord.
May it please your lordship. I am with regard to item number 31, lordship.
31 is not NDPS POSCO.
It is a POSCO matter, lordship. And petitioner is behind the bar for the
Just a
last.
minute. 23 we have done, no? 23? 23 and we have done. 24 we have done, no?
This is for a CD level, 23 and 22 CD.
I'll have to keep the CD. I'll have to take the CD. I will do it, try to do it within 3-4 days. No? Try to. Okay. So 31, yeah.
31, lordship. 31, Lordship. It is a POSCO matter, Lordship. I am behind the bar for the last 395 days, Lordship. Here also, Lordship, section 36 of the BNSS is not followed, Lordship. Kindly peruse page 22, Lordship.
Mix up with the borough. Just a minute. Number 23, 24, 38. So, 31 করে আছে। এই দুটো আছে। Yes, please.
Lordship, the petitioner is behind the bar for the last 395 days, Lordship. Here also, non-compliance of section 36, Lordship. 36 is at page 22, annexure E, Lordship. In this regard, on the last occasion, I have submitted several judgments of the coordinate bench of this honorable court, Lordship, including judgment of your Lordship also. And Lordship, since this matter has already been submitted by the learned counsel of the other cases, Lordship, so I don't want to burden this court anymore, Lordship. But Lordship, kindly pay to section 36, Lordship. Once again, Lordship.
Yes, tell me.
Section 36.
Reform it.
From B, I will start, Lordship. 36B, Lordship.
Yes.
So here it is specifically stated that prepare a memorandum of arrest, which shall be one attested by at least one witness who is a member of the family of the person arrested or a responsible member of the locality where the arrest is made. 2, countersigned by the person arrested, Lordship. Then it comes 3, Lordship. And 3, inform the person arrested unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest, Lordship. So 36 will come before 48, Lordship. So 48 cannot override 36, Lordship. So 36 will come before 48, and 48 cannot be seen as a substitute of 36, Lordship. Now kindly peruse section 62 of the BNSS, Lordship.
Yes, all arrest as per the Sanhita.
62, Lordship. Arrest to be made strictly according to Sanhita, Lordship. 62, no arrest shall be made except in accordance with the provisions of his Sanhita or any other law for the time being in force prevailing for arrest. So if section 36 is violated, then section 62 will automatically be violated, Lordship. So it is a violation of statutory provisions, Lordship. And regarding constitutional violations, Lordship, D.K. Basu has already elaborated this issue, Lordship. And relying on the D.K. Basu's judgment, Lordship, I have already pressed the D.K. Basu judgment, Lordship. It is probably in the file, Lordship. Relying on the D.K. Basu's judgment, Lordship, paragraph 36(2), Lordship. Lordship.
Compilation to good. একেলগে বান্ধি দিছিল যে compilation.
Probably it is in the file also, Lordship, that earlier day I have submitted.
Yes, it should mean. Yes, tell me.
Section 36(2), Lordship.
So,
Or paragraph 36(2), Lordship, of D.K. Basu judgment, Lordship.
Yes.
Can I go through it, Lordship?
Yes.
That the police officer carrying out the arrest of
36(2)? No, it's different.
36, paragraph 36(2), Lordship.
Oh, no, 30, it is, you're reading from SEC.
Lordship, I am reading from AIR, Lordship.
Sometimes the paragraphs differ. Here, anyway, I can follow it. Here it is 35(2).
Okay, Lordship.
It should not actually. The para given by court should be the para for all journals.
Lordship.
But they change it. Anyway.
That the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may be either a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall contain the time and date of arrest, Lordship. Now comes to paragraph 38, Lordship. Probably it will be 37, Lordship, there.
Yes, requirements.
The requirements referred to above flow from Articles 21 and 22(1) of the Constitution and need to be strictly followed. These would apply with equal force to the other governmental agencies also to which a reference has been made earlier, Lordship. Relying on this judgment, Lordship, your Lordship has already passed an order in BA 3373 of 2023, Lordship, which I have already submitted, Lordship, discussing these DK Basu judgments on non-compliance of section 36(2) of the BNSS, Lordship.
Okay.
So section 36(2) has been elaborately discussed with DK Basu judgment, Lordship, in BA 3373 of 2025, passed by your Lordship. So basically, Lordship, the law is clear. 36 is separate, 48 is separate, Lordship. There cannot be any submission that 46 can override 36, Lordship. Or if 46 is 48 is complied with, 36 need not be, Lordship. So at this stage, Lordship, since already this issue has been submitted by the Learned Counsel of the other cases, Lordship. So at this stage, Lordship, I am praying that the petitioner may be granted bail for for violation of section 36(2) of the BNSS, as well as Article 21 of the Constitution of India, Lordship. And Lordship, another small submission is there, Lordship. If this issue is sent to revision bench for further consideration, Lordship, then the interim prayer of the petitioner may be considered, Lordship. Otherwise, the petitioner will be highly prejudiced, Lordship. That is my humble submission, Lordship. And regarding judgments from the other coordinate benches regarding 36(2), I have already submitted, Lordship, the earlier day, Lordship. Oblige, your Lordship.
Was completed, no? Only one left, 28.
Yes, my lord, 28.
Please complete.
Yes.
5 minutes we have. I have to
Please,
rise
your
on
Lordship.
time today because I have work.
Yes. Your Lordship, in my case also, 36 BNSS is also not complied, my lord.
Just
I have a judgment of the
item number,
coordinate bench.
item
Item number
28,
28, my lord.
28, oh.
8 minutes, please, thank you.
Again,
23, 24, and 28, I will hand over the.
yes.
And my lord, in my case, my lord,
In your case, which
my lord,
notice is not complied? 36.
36 BNSS, the arrest memo.
No signature.
No signature in the arrest memo of witnesses. And my lord, the notice 48 also not complied.
48.
48, yes, my lord. The family member of the accused person did not get any notice regarding his arrest, my lord. And my lord, in this case, the present accused petitioner, he was only the driver of the vehicle, my lord. My lord, kindly see page number 41, my lord.
Have to police of work. Is not permanent. Oh, no.
That is.
It was only the driver
Yes, my lord. My lord, kindly see page number 41.
of your petition.
41, my lord, of the petition, yes, my lord. The judgment of the coordinate bench, para 3. A perusal of the case diary, it is revealed that 10 cartons containing 3,000 bottles of phenacetyl cough syrup were recovered and seized from the truck bearing registration number S01NC3916, driven by the accused petitioner. The FSL report shows that sample of phenacetyl cough syrup gave positive test for codeine, present codeine phosphate, and contain 186.5 ml per bottle. It further transpires that the accused petitioner is the driver of the truck of VRA Logistic, and it is his duty to deliver the consignments of various goods loaded by the said company to the consignee as the consignment as the per challan. After thorough investigation, the investigating officer in his note dated 7/3/2022 noted that the seized cartons bore seal and pack of VRA Logistic Company and loaded for transportation by the company truck driven by the accused petitioner for delivery. Under the last paragraph, the last line, my lord, it has been further noted that narcotic suppliers, peddlers misuse the vehicles of VRA Logistics to fulfill their malicious intent, which were just carried by the accused driver. This finding of the investigating officer is, of course, subject to final outcome in investigation.
Therefore, the court is prima facie of the opinion that regardless of section 37 of NDPS Act are not attracted in the peculiar backdrop of fact and circumstances concerning the present accused petitioner. My lord, the mic is the same, my lord. He was only the driver, my lord. He has no knowledge about the substances, my lord.
No.
And today's, my lord, 71 days completed, and 36 of BNSS is not complied. And my lord is totally violated the fundamental right of the accused person, my lord. Obliged, my lord.
If you want to give something, you can give it in points and give it later also. Because obviously it has to be reserved.
But I've got two other matters, my lord, that is 19, 20 and 54,
Let us fix it tomorrow and take a chance.
all the three.
On the tree.
Yes.
No, you want
19, 20 and 20, 54.
54. Any other urgent matter here?
My lord, item number 59, man. I for bail mal pending appeal, man.
What is the sentence?
Sentence is for my 4 years, man.
4 years.
Already almost 2 years, man, completed, man. There is also no evidence, my lord.
It will be
Tomorrow,
tired.
my lord, if possible, kindly, my lord.
Time constraint is there, but. Hmm. Which one? Not to served. Do you, then you take instructions and let fix it immediately after reopening. Will it be okay?
My lord,
Huh?
tomorrow, my lord, kindly.
No, but notice is not served, he says. Otherwise we could have taken a chance.
Then in the, my lord, vacation code, my lord.
Huh? Okay.
Then I'll, my lord, and in the vacation code, my lord.
Vacation code is only for urgent matters actually. Anyway, 2 years he has passed. No?
21 and 20.
There is no evidence at all, my lord.
Make a mention. Oh, I'll switch it.
21 and
My lord, 19, 20 and 54, what to do?
Let's fix it tomorrow. Tomorrow list, the first
Yes.
list has come, I've seen. It's
Yes,
manageable.
yes, tomorrow, my lord.
It is not unmanageable,
Yes,
but new matters may come.
exactly, my lord. So many
So, but we'll take a chance.
if possible, we'll
We'll take a
21
chance.
and 22.
Fix it tomorrow, no problem. We'll take a chance.
develop. my lord.
We'll take a chance. We'll try. Tomorrow I can sit a little late, but today I have work, so I have to rise.